morning, recently appointed, Mr. Danny Louie, physical therapist, and Mr. Adam York. And if you, Danny would start off and just introduce yourself and tell us a little bit about you.
Yes, my name's Danny Louie, originally from Alexandria, Louisiana. I have 3 kids, 2 girls and a son. Both my daughters go to Alabama, so it's kind of crazy because I live in Baton Rouge. My son, Catholic high school, Louie Physical Therapy in Baton Rouge. We've been open going on 24 years now. So we've been thriving and dealing with the outpatient world in the Baton Rouge area. So we're loving physical therapy. Done a lot of things, been out, graduated in 1992 from LSU Med Center in Shreveport. I've been a physical therapist for a good bit now. So I'm excited to be on the board, excited to be here and help out as much as I can help.
Wonderful. Adam?
Yep, Adam York. I'm from right here in Lafayette. I'm actually from Youngsville. Been here my whole life, 42 years. I graduated here in Lafayette, and I've actually, after high school, my high school was so big that the guidance counselors just pass out little flyers and fill out what you might want to do when you grow up. And I had no idea, so I did massage therapy right out of high school. I worked at the physical therapy center. I realized that I need to go back to school to do a little bit more, make a little bit more of a difference. And so I did that. Went up to Bossier Parish Community College up in Shreveport, and I did that. Came back down, and I worked in New Iberia and outpatient for a while, and took a little PRN job on the side doing skilled nursing, and I fell in love with that. Fell in love with just the outcomes and the reliability on dependability on getting them back home, right? What they need from you to get back home, as opposed to doing some less than therapy versus aggressive good therapy, get them back home, making a difference. And so I've been there in and out my whole career. I've done some home health for a while. So, and I've worked in some rehab too. And I enjoy rehab. But I just feel like skilled nursing's always been my thing that I've always fallen back on. And I just really love the appreciation you get from sending somebody back home and things like that. So I've been there in and out my whole 17-year career. And that's where I'm at right now also.
And if we would go around the table and introduce ourselves to these gentlemen. Katie?
Yeah, my name's Katie Britton. This is my 6th year on the board, and I'm from Lake Charles.
Phil Page, Baton Rouge, brand new professor, and finishing my 6th year. Was also a member of the advisory board for about 2 years before that.
I'm Alice Lashley. I'm board compliance counsel along with Jim Raines, who's attending by Zoom today. I'm from Lafayette.
I'm Deanna Narcisse. I am originally from New Orleans, but I live in Lafayette. Well, I've been here for 18 years, so I went to USL and UL. And I'm the consumer member. I'm actually an educator by profession.
I'm Lee Riley, and I'm originally from Massachusetts. And so I came to Louisiana in 1998, and I came to work for the Willis Knight Health System, in Shreveport, Louisiana. And I've been with them ever since. And this is my 3rd board meeting. Yeah. Recently appointed to the board. I was nominated by the Hospital Association. So.
Right. O'Day Laverne, I'm currently the board chair. I'm in my 4th year. So I'm in my 2nd term, and I'm in private practice in Alexandria. I'm originally from Rayne, and welcome to the board.
Thank you. Thank you.
I'm Charlotte Martin. I am the executive director of the board. I have been here since 2014, February of 2014. And I am from Crowley, Louisiana, loud and proud, Rice Capital. So not too far from Lafayette.
I'm Jessica Olwell. I'm the assistant executive director. I've been here since January 2018. And I'm originally from the Alexandria area and have been in Lafayette since I got here. No plans of leaving.
I'm Ann Mims. I'm the administrative assistant. I will be here a year in September. I'm an Army brat, so I came down here from Fort Polk, now Fort Johnson.
And members in the audience?
I'm Mary Adair. I'm part of the advisory committee.
Great. Marcus Houston. Nice.
Hi, I'm Yari. I'm a student intern for the physical therapy board. Nice to meet you.
Great. All right, welcome, everyone. All right, next on the agenda is to approve the agenda. And before we do so, I will let you know that we have the choice to either amend the agenda now or later, as we have had a second consent order added. We can, choice of the board, we can address that issue when we get to consent orders, or we can change the agenda now.
Make a motion to amend it to accept it.
All righty. And also, we have with us today a licensee by the, Mr. Marcus Houston, and Marcus is coming off of suspension. And, he is listed under new business, and he is with us this morning. Won't take very long, and I would ask upon personal privilege to address, his issue today, and out of respect to his time, and move him along. There's no problem with that. All right, although.
Move it up into the agenda sooner.
Yes, we'll move them up in the agenda, all right? All those in favor of approving the agenda as amended, vote by saying aye. All those opposed, vote by saying nay. The ayes have it, the agenda has been approved. All right?
Who seconded? Did somebody? You got that?
Didn't hear a second.
Okay.
Katie seconded,
Okay.
yes, it's so approved by, moved by Phil, seconded by
Okay,
Katie.
thank you.
All right? All righty. And with that, Mr. Marcus Houston.
If it's okay, I'll just
Yes, ma'am,
introduce
please.
this matter. So, in your board meeting prep materials, you should have received a consent order that was approved in December of 2023. And that was in the matter of licensee Marcus Houston, who is here today. It included in the order a suspension period of 6 months. And so now that we're entering June, as of June 14th, the suspension period will be complete in terms of 6 months. Mr. Houston did have to complete some things during the consent order, and everything has been fulfilled. We received the certificate for the PBI course as well this week, and he just completed that. He's also here present in the room if you have any questions for him. But today, what your business is to authorize the staff to move his status from suspension to probation if you feel like he's satisfied all the requirements of the order. Can you go to the motion? Let's see.
Charlotte, can you confirm that Marcus has satisfied all requirements?
I can confirm. I also spoke with Stephanie this morning. Stephanie is out today, and she seconded my confirmation.
You tell me the confirmation.
Marcus?
Yeah.
Can you just tell the board what you've learned from this experience?
It was definitely a humbling experience. The PBI course was, I think, a professional game changer for myself. Just learning how to do business in a better manner, in a more professional way, to just to be a better physical therapist to the public and to my employees.
Very good.
Great. Any other questions?
And I'll just point out that we did not request or demand that Mr. Houston be here today. He did this,
Yes.
voluntarily and drove over here to be here and present for your questions. So we thank him for coming over here.
Thank you, Marcus.
We usually like to ask people about the PBI course, and we've always gotten really great feedback. And it sounds like it was a positive experience for you as well. It's like, would you recommend that course? Continue to be a part of?
Cost of the course.
Sure, yeah.
I would recommend that every therapist take the course, whether it's due to a suspension or not. I choose my words wisely, but I think it's something that everyone can learn from.
That same response is consistent.
That's
Yes.
correct. That is,
Yeah.
that is correct.
Thank you for that.
Yes. Okay,
I make a motion to move him from suspension to probation.
we have a motion.
I'll second it.
We have a second. All those in favor, vote by saying aye.
Aye.
All those opposed, nay. Any abstentions? The record show that everyone voted unanimously. Okay, and for the record, yesterday, when we spoke to the two of you, Mr. Danny and Adam, we spoke about the chair voting, right? Is when it's a voice vote, the chair will vote, okay? When there's no nays or abstentions, then we always like the record to show that it was a unanimous vote, right? When we have a roll call vote, if anytime we don't know the difference if the nays or the yays won, or if it's a particular matter of interest that people request a roll call vote, then as the chair, I will vote last, and only then if I need to break the tie, okay? All right, so I just want to be sure that, you know, as we try to speak, we speak in complete truth, so everyone has a great understanding of how we're operating.
Thank you.
Okay, great. All right. Mr. Houston? Congratulations. Thank you. Hope you're well in your future.
Thank you.
You're welcome to stay for the board meeting if you like. Okay, we're good.
Oh, I don't have.
All right, good deal. I thought you were sending me a note. All right. All right, so next on the agenda, we'll approve the minutes of the May meeting. Everyone has had those minutes sent to them ahead of time. Hopefully you've had time to read them.
Make a motion to accept them.
We have a motion, and do I have a second?
I'll second.
We have a motion by Phil, second by Lee. All those vote in favor, vote by saying aye.
Aye.
All opposed, nay. Any abstentions? The ayes have it. The vote reflects unanimous approval. And next, we're gonna go into special programs. We have a presentation today by PBI for the board.
Are they logged in on the Zoom yet? Okay, we're 15 minutes ahead of schedule
Okay,
for them, so
all right.
you want to come back whenever they log
We
in?
sure can.
Okay.
All right, next item on the agenda are consent orders.
I would go to officers report next, just so that, because we only have 15 minutes.
Okay, all right. If there's no opposition, we'll go to officers' report while we're waiting for our presentation. All right. Chairman, no report. Treasurer, no report. Executive Director, Charlotte.
Okay, so for the licensing report, this is individuals who have been licensed since the last board meeting. Jessica, do you mind even, things are. That's okay. We've licensed 79 PTs since the last board meeting. 60 of those were initial, which makes sense since we're in graduation season. 2 were by reciprocity, meaning they came from another state. And 17 were provisional, meaning that they're pending examination, for a total of 79 PTs, and then 10 PTAs, 2 were initial and 2 were reinstatement, and 6 were provisional. Total of 89 complete. So Danielle's been busy. For the physical therapy licensure compact, since May 10th, we have received 7 initial PT compact privileges for people practicing in Louisiana. 6 individuals renewed, so that's a total of 13. Year to date, we've had 89. So the compact is live and well. And then in terms of our complaints, we have 21 open cases regarding licensees, and there's the breakdown you can see. We have 1 open case regarding an individual who is not licensed by our board. And then since the last board meeting, or since it says May 10th there, but I believe this last board meeting is, we've received 2 complaints. We have had 1 informal conference. We don't have any hearings that are currently scheduled, no appeals. We have proposed 2 consent orders, and you'll be hearing those today. And then we have 1 closed case with a letter of concern. And I can give the real estate update as well,
Yes.
if you want.
All right, any questions of those reports for the Executive Director? If not, we'll move to committee reports. And we have a update on real estate from Charlotte.
So at the last board meeting, I believe that I mentioned we were submitting a letter of intent. We did receive our letter of intent. The landlord had one change to the floor plan because one of the walls that we were proposing to move was a load bearing wall. So they provided a slight revision. Didn't really make any difference in terms of our functionality. So I approved that floor plan change. We were supposed to hear back if they approved our letter of intent Friday. Said, give us till Monday. Yesterday, I said I didn't hear Monday. They said you'll hear it by the end of the day. And if I heard by the end of the day, I don't know. No, I didn't because I checked my email. So if they heard by the end of the day, I don't know. So I should have an answer very soon. And what we're looking for is, are they accepting, they would need to do the tenant improvement that we requested. And we also requested some other things, like there's furniture available, things like that. So we're going to see if they accept it or don't accept it.
Can you remind me the next step after this?
Yes, so if they accept our letter of intent, then we send the letter of intent to the Division of Administration, which is the Office of Leasing, and they will draft the lease. And in the lease, it's gonna have all kinds of statutory requirements that are in there. So then that will be sent to the landlord. And then the landlord will say whether or not they agree with the requirements of the state. Now, this particular landlord has dealings with the state because they do, work with LSU and like other groups. So it's fine. They're the Lemoyne company, big construction firm. So the landlord should be okay with it. We don't know. So if they're not okay with it, they'll come back to us and then we'll have to work through the state. We do have an attorney who can help us with this in Elisa's office, Eric Landry, if we have any run-ins. And then once our landlord says that they're fine with it and they sign it, then it gets sent to me. I'll sign it, and the board, I believe, I'll have to double check this, but if my memory serves me, you all did authorize me to sign on a lease. So if that's still valid and wonderful, and it wasn't specific to a specific place, then we'll need to get that authorization. And then from there, they will begin construction. I'll need a request from them, a time frame from them on construction. And then we would, after signing the lease, we would purchase whatever furniture we need to purchase. And because that has a period where it has to be, and then I'll have an update for you guys on like the time frame for the construction and when the furniture is going to come in and then what to expect. So.
Can you remind me when the lease on this property expires?
It expired December 31st.
Okay, so we are just.
We're on a month to month.
Month to month, okay,
We are.
thank you.
You're welcome. We consulted with Division of Administration on if we should sign a lease that says month to month, and they said it's the same thing as what you're doing. And so it's kind of like, just keep doing it. Because it would say month to month, they have to give us 30 days notice before letting us leave. Or it might even be 60 days. So, yep. So we are, okay. We had a rain again over here, and whenever it rains, the rain comes through the windows and everything. Yes. And we've known this, and it smells really bad in here. And we had this last time we had to have fans brought in. We've notified our landlords over and over, our landlord. And so this time, whenever I got in the office, Jessica showed me a Petri dish that was ordered off of Amazon just to see, like, put it out in the air, and it had mold all on it. And so that was very concerning. So we were sending that off to see what type of mold that was and to share it with our landlord to see if they can evacuate the mold. And then we did a purchase of air purifiers for all the offices because we're concerned about the health and safety of our employees. We'd like to get out of here as soon as possible. And we did offer for Danielle, because Danielle's office is the worst. We offered for her to be able to work from home as much as she would like, and also to move her workstation to one of the conference rooms where it's less potentially dangerous, but we are, responding to that. So that is what's going on over here.
They're not, I have emailed them again and also reshared the registration link. I'm monitoring that right
Okay.
now.
All right.
Unfinished business?
Yeah, we were rolling. We can move into unfinished business. Any questions on the potential lease, the current lease, the status?
You want unfinished business and not consent order?
Correct.
All right, unfinished business. First, the May meeting, Secretary Treasurer Britton moved to have the Executive Director and the Board Attorney Jim Raines to draft a response to be reviewed and approved at the next board meeting. All right, the question asked, we have been approached to provide wellness services in a new med spa opening in my area. They have a physician on staff and will be providing a wide range of anti-aging services, including rejuvenation modalities. I understand my role as a physical therapist in providing wellness services, but I am unclear on providing these rejuvenation modalities. There are a number of laser schools recognized nationally for certification to perform these services. If I become a certified laser technician and perform skin rejuvenation treatments, will it conflict with performing wellness services at the same location? Would skin rejuvenation be considered part of a wellness practice under my current physical therapy license? And Jim and Charlotte were going to share the response that they're prepared for us on this.
So, Elise provided a response that is in front of you in a hard copy. And also it's up on the screen. It's a little harder to read on the screen, but we thought for the Zoom members, so it's in front of you printed out. And so, if you don't have a copy, let me know. Does everyone have a copy?
It's that one.
Okay, and so, if you want to take a moment to review it, and then, we'll turn it over to Elise to explain or answer questions.
Yes.
So you're saying, answer to question 2, depends on whether it's being provided for wellness purposes. That reads to me saying, if skin rejuvenation is for the purpose to prevent injuries, reduce stress, or promote fitness, it's okay to do.
That's what the practice act says.
That's, so if I'm saying, I look better, therefore I'm not stressed, does that work?
I think the physical therapist could approach it from that direction, and of course, that's also one of the reasons why we have the additional guidance of the last paragraph, which
Yeah.
says if you are going to consider it, if you're going to treat it as being provided for wellness purposes, please be aware, be reminded that there are screening and documentation requirements that apply. So the last paragraph is not, they're not specifically requested, but maybe helpful guidance we may want to add on to our response.
Do we want to ask for clarification?
Say that again?
We want to ask the licensee for clarification regarding, what their understanding of the skin rejuvenation services.
That's a question for the board. How much do you want to dig into it? How do we typically treat these questions when they come in? Do we take the information we have and provide a response with what the information we're provided? We do like to, my opinion is we like to refer the back to the Practice Act and to the board rules as much as possible. And because that falls within their judgment.
Is that the precedent?
Yeah, so I would say like a response similar to this one, and then they can always come back to us and say, okay, I thought about it, you know, now I have this more specific question and kind of what's happened, I think, in the past. They may go, that's enough for me to feel comfortable, make a decision. It's a good question.
Does anyone know, we had a question, what is a certified laser technician? Is that something you have to have? Did you use a laser? Like they
go through training. So the laser is a piece of equipment.
but are you required to have a certification to put a laser to fix someone's skin? Is the question.
I don't know the answer.
And that might change too. They're gonna develop new technology, right? So one of the benefits of answering it this way without digging too much into it is the answer could change depending on the information that comes in, the type of laser, the type of certification, right? This refers the licensee back to the Practice Act and says, here's what you're required to follow. And you use the information you have specific to your situation.
My understanding, if you want a job in one of the facilities, your potential for employment would be increased if you had gone through and getting certified as a laser technician. And it would be something that you would want to do in order to work at one of these
Yeah.
facilities to increase, the liability on being something for the position.
But it's not required. That we know.
Probably not. And so I'd like to drag the point out of you, if you have a point to make about the necessity of a certification or not, is that
Yeah,
important?
The point that I have is that if it requires a certification, that means it's another scope, it's another thing that someone else is doing. I use this kinesiotape certification. You don't need that.
Right.
Right? It's part of your scope of practice. It's just to make money for these companies. But if you want to get hired somewhere and you put on your resume, I'm certified kinesiotaping, great, whoop-de-doo.
Yeah.
This, I'm saying, is this something that's required to do that task? And if it is, it seems like it's outside of PT. That it says additional certification.
My only comment would be, in the event a claim was filed against this licensee indicating that the individual was harmed as a result of receiving like the laser treatment, then we would require, evidence to suggest that they were properly trained.
Correct,
And that they were competent to perform this technique.
correct.
And so in the event that this individual became a certified laser technician, that could be presented to us as evidence of appropriate training in the use, of the laser.
Yeah, I agree.
Good question. And that's kind of specific with a lot of different things, we're talking about, claims and stuff like that, competency, checklists and stuff like that and signed it. I know that's, on his side, on their side, getting that competency check off and clarification, would help out with that case, like you said. But is that something it's something that we would respond to them on that? Or is that just something on his side that he would protect himself or herself in that, competency thing? Because I know that we're talking about a response to them sending this kind of a vague and open-ended, I understand that. But is that something that we need to protect ourselves with that response? Sending them the clarification that, hey, this looks good, and giving them the understanding that they could proceed at will with what we feel like is appropriate. But do we need to have requested that competency, or is that just on them personally in a legal matter?
Are you saying in the event that a complaint comes in? they have
Sure,
someone-
and a suit that comes, which is all the time, just competencies. I know that wound vacs, those types of things, those competencies are always required in all facilities that I've been in. And so that's at a level there versus just on a board level, protecting ourselves from that, that's just on them and their clinic. So is that something that that we would have to state to oversight, or is that just basically them to do on their own stuff to protect themselves versus protecting ourselves?
Can I make a comment on something that we have put in a statement in the past? And something similar to what you're going at, we would say, be mindful that in the future, like you must have the education, knowledge, experience, training to do things, and you may be requested to produce certificates.
Yeah.
And then like cite 197, which says, you gotta keep your certificates for 4 years, something like that. So like at any time that can happen, and we'd have, the attorney draft it the right way, but just to kind of put a reminder in there to be helpful.
I think that'd be good.
Not-
And to safeguard him as well, in case
Right.
something does happen.
Absolutely. Absolutely.
And,
You gotta.
and it won't say shall, it would say like, be mindful that this could occur.
Sure.
Is that something you're comfortable with? Okay.
Just, because we're looking at protecting them as well. I mean,
Right.
we want to give responses to protect our members. Not like we're trying to guide them in one direction versus the other. But if there's something in the
Could be
wording
more
that you
helpful.
said, I think that would be beneficial.
Right.
Yes. So to your point,
Yes, sir.
we always want to try to be helpful. Our job here is not to protect the
Sure,
licensees.
sure.
Our job is to protect the public. Now, in doing so, we have to guide the licensees, okay? I'm a little concerned that I see twice in here, it says when you're performing things outside of the scope. Okay? I'd like to see us address today's questions and the questions for the future. When things may be invented, new techniques, new equipment that we have not heard of yet, all right, is to say it is or it isn't prohibited. If it's not prohibited, okay, then if you have the training and the expertise, get after it and be careful. Okay? As opposed to saying that you're providing services outside of the scope. Because I don't feel as though we directed you as attorney to say that what she's doing is outside of the scope. What I think we assigned was, it's not prohibited, give us some advice. Okay, and so I'm really not comfortable saying that these things are outside of the scope, because I don't know that they are outside of the scope. They're not prohibited, so I think they are inside of the scope. She's working with the integumentary system. I don't know that because it's at a spa that it means it's wellness, okay? It might be physical therapy as opposed to wellness. So when we answer our question, not only this question, is that we have to say, is it when you're being a physical therapist? Okay, no matter what setting you're in, whether you're in the nursing home setting, the wellness setting, the practice setting, you have a responsibility. And you're always going to do an assessment. You're always going to have a treatment plan. And it's up to you to decide how you do it, if you do it, but it's not prohibited. So I'm a little not comfortable with making references here that what this person is requesting to do is outside of the scope. Because I don't see it as being outside the scope.
So I read that sentence a little bit differently, not saying that it is outside of the scope. I can understand your concern about the language, but I think it's an important concept to say that, like, if you're doing something, because the big question that comes up is, I'm doing this activity and I'm not acting as a physical therapist in this role, right? And so that's one of the components of a question like this that gives people pause, right? And so if they're acting in a role that they're not utilizing their physical therapist license, they're working under a physician separate from their physical therapy. If they are acting in a way that, and we could change the word instead of outside of scope to something else that kind of mimics, because is that the intent of that sentence? It's like if they're performing a service, not as a physical therapist. Was that the intent of that sentence, of why it's there?
Because I think that's the nature of the question.
Yes, that is the nature of the question.
I think the nature of the question is, can I, as a licensed physical therapist in the state of Louisiana, provide skin rejuvenation modalities to my patients within the scope of my practice? She's not asking that question. She's asking, I'm gonna be working at a wellness spa.
Under a physician,
Under
under his
physician,
direction.
Under his direction.
Yeah.
And I'm going to be providing wellness services at the spa. In addition to that, I
Right.
want to provide skin rejuvenation treatment as a certified laser technician. And is that a conflict? That's my reading of the question.
So I like that you have that last paragraph that says, just be mindful. So we only have the authority of the Practice Act, right? But in the event that this person does something, even in that different role, if it violates the Practice Act, they can still come before the board, is the intent of what I'm reading of that paragraph. So let me know if that's wrong, but we can change from outside the scope to a better word if that's
Yeah.
the part that gives you pause.
Yes,
Because if the services were to be performed within the scope of physical therapy,
Right,
then there would
No
have to be an
brainer.
evaluation done.
right.
sure.
There would
And-
have to be documentation to support the medical necessity of the skin rejuvenation services.
Right, and that's the
And then there would
third,
Have to be a
yeah.
plan of care developed.
Yeah, and that's the third bullet here is, would skin rejuvenation be considered part of a wellness program under my current physical therapy license?
Right.
Okay, so that's, now she's asking the question, and it's specific to wellness. Her question is specific to wellness, and can they do skin rejuvenation under wellness?
I think part of the problem with this is the word your. Your physical therapy practice, the scope of your. It should be the scope of physical therapy practice, because we talk about personal scope.
Yes,
So that's what this is saying is,
Yeah,
I wouldn't even put your in here
Yeah.
because they shouldn't be doing something outside of their scope of practice, their personal scope of
Yeah.
practice. It should be within the scope of physical therapy practice.
may nevertheless be potentially brought towards the board if
Right.
it violates the practice
Right.
act. Yeah,
at the bottom paragraph,
Yeah.
yes, yes, yes.
So the word your needs to be struck from the draft.
yes.
Got it.
Would we strike it also in answer to question one?
Yeah, that's what it's,
Okay.
is there one and two?
There's one at the bottom paragraph too.
Where's the bottom?
Last paragraph.
Right there, third sentence.
Yeah.
Yeah,
Scope of
Yes.
your
Oh,
physical
yeah.
therapy practice.
Scope of, yeah, I would just strike that and just remove your, just put.
In all the
physical therapy,
places, yeah.
all physical therapy practice.
So now we had concerns is that when do you have your PT hat? And when can you walk out of the room and go be a not a PT hat?
Right.
If,
That's part of my question is I'm
Yeah.
a certified athletic trainer and I wear two hats and I work under a physician. I can go over here and work in the training room as an AT. I can work over here in a PT. That's what I'm asking about certification. So if that's requiring certification, that's another hat.
Yeah.
That's not PT.
that's correct,
That's what my question.
that's correct.
So yeah, if you're certified and you're not calling it PT, that's totally fine with me as long as you're doing, you do you.
And I think that's confusing to the licensees. Yeah,
It
like,
has been for 20 years.
yeah, right. Like if I'm practicing yoga, am I a PT practicing yoga? And it's like, well, are you
I think
calling
it's what
yourself
you
a
Call it
PT?
and what you bill it.
Yeah, okay, call it a bill. Okay.
My opinion is this doesn't fit under the wellness definition of physical therapy. It's laser treatment, rejuvenation. I get the point that it's integumentary and I'm okay with that, but the way that the definition, as I said, of wellness says reduction of stress. Does that mean I look better, therefore I feel better? That's my question.
In the training, at the university that the students receive in terms of integumentary system, is skin rejuvenation modalities included in the training?
Not that I'm aware of, no. It's wound care.
So then, again, if we had to investigate, a claim, to determine if the individual receiving these interventions was harmed, we would look and see was it part of your training? Did you receive training, as part of your primary degree training program, in skin rejuvenation? Did you have additional training postgraduate in skin rejuvenation? If you were claiming it was part of your practice, within the scope of your practice.
So does the laser that you do in the clinic, we do, you do, we do, who does? I'm not asking anybody in particular, all right, but we use laser in our clinics today, and we'll use them for scar healing. We use them for wound healing. We use them for tissue healing. Is that not skin rejuvenation? See, we do it every day.
But they have a condition already that you're addressing a scar. You're not tightening up wrinkles. That's different.
Well, skin rejuvenation is not defined.
right.
That's what I'm trying to get
Yeah.
at. What is it? I don't.
Yes,
Well, that's why I think the way that you answered
And
it is perfectly appropriate.
Right, the way you answered is fine. They have to make that decision.
yeah, so unfortunately, the answers that we give have to be to the questions that are asked. And we'll keep saying, the answer to the question is in the question. Okay, that's what my educators in the room have taught me, all right? The answer to the question's an answer. We can only answer the questions that were posed to us as they were posed. I think her question can be a little confusing.
As a consumer, you know, would you find it confusing? If physical therapist was wearing a hat at one part of the session and then taking the hat off during another part of the session?
Absolutely, because I already know they're a physical therapist.
Right.
So I would probably think that, you know, this is therapy also.
You wouldn't be able to make that determination, just drawing that distinction?
Well, that's why I'm glad that the last paragraph is there. So the way that Gwen Simmons talks about this topic that Charlotte mentions is so confusing for people is it has to do with duty, right? Like, do you define a duty, right? And so if you have an established relationship with a person, and so again, that can be a varying situation, right? Depending on the person, the client, the patient, or whatever, but are you creating a duty? Because we have a professional duty that's defined in law, right? And so that's an important component of it. And so, if they can differentiate that and create an environment where they don't have a duty, right? Then that kind of opens that lane up. And I like that definition, the way that she talks about that as the defining factor. Again, it's not something we've all agreed on as a board to say like, that's a helpful tool. But it's a published document that's in a journal that a lot of people reference that I think could be a helpful guidance on the matter if that particular question comes up to us in the future. But I like saying, like, you think you're not being a PT, but if there has established that duty, that professional duty, then you could be subject to a practice act violation potentially if a harm happens.
I mean, there were days when you could not act as a physical therapist without a referral,
Right,
which meant I couldn't sit in a physical therapy row at church. I couldn't wear my physical therapy T-shirt. I couldn't give someone advice on the wheelchair ramp.
right.
You couldn't act as a physical therapist without a referral. If that was the case, we have broke the law every day, every one of us, because we act as physical therapists all day long, all night long. It's hard for us to get out of that mold.
Right. So that's why that it's hard to come out of that
Yes.
mold and you're trying to differentiate. So that's why I like that duty. And like she defines what that looks like. So like if you make, like you're talking about something and you notice that they have a limited motion or something, and you make any comment or anything, you've now established that duty, you know? And so anyway.
Yeah.
That's a good point.
Yeah, if you stepped outside of the technician
Uh-huh.
hat, if you stepped outside of the role of technician, if this individual is truly working as a technician
Right.
under a physician and
Right.
under the direction of the physician, then they're not developing a plan of care.
Right.
You know, they're not, developing, they're not doing any additional tasks outside of what they were directed by the physician to do. And so long as the individual stayed in that lane and didn't cross over, into a lane where it could be perceived to be functioning as a physical therapist. Again, it comes down to, in the event a claim was filed against the licensee that they were harmed as a result of them acting in this capacity, then we would have to then investigate that and determine, okay, where did you cross over? Did you leave the technician role and cross over into the physical therapy role? And, and was the consumer, was the client clear in the differentiation between those roles? So.
Right, like that.
I don't think we have to necessarily
Yeah.
include that in this response, but it's good for us to have to talk through that because it is something that's confusing and it is brought up occasionally and it's a hard question to answer.
Yeah.
And
And if they disclose that in like in something in the clinic, and like a document that they would sign, something like that. And obviously to make that much more simple and they would have concluded that in here, but that's just outside of where we are. That's just inside their clinic, disclosing that information, that this is separate roles. Then
And
if they submitted that with this, it'd make it a lot easier.
As you said, all we can answer is the questions.
Exactly.
Yeah.
Provided, we can only answer these questions, if these are the questions that we.
So the question, would skin rejuvenation be considered part of wellness practice under my current physical therapy license?
yes,
Have we answered that?
yes, minus the your.
Yeah. See,
And if you, I like what you said, if it's a scar, if you've undergone surgery, yeah, it's PT. If you're just coming in and get your wrinkles fixed, that's not PT. That's
Yeah,
my
I mean, in her question, if I become a certified laser technician. The question is not, is skin rejuvenation treatments within the scope of physical therapy practice?
Right.
So what she's asking is if I assume another role, if I become a certified laser technician, will it conflict with, my ability to perform wellness services at this location? But when you perform wellness services, you are functioning as a physical therapist.
Right.
And you are within the scope of physical therapy practice. If you become a certified laser technician, as Phil said, now you're wearing a different hat. And as we've discussed, it is precarious, for the licensee when they're trying to fulfill two roles with one client.
And she's one, maintain that role underneath the PT hat as a certified laser technician.
Well, that's not what she's asking.
The same location.
She's gonna be providing wellness services at this med spa.
Right.
My interpretation of the question is there's the potential for her to gain additional income by performing laser treatments as a certified laser technician.
Right.
And so in addition to the wellness services that she'll be providing at this spa, can she supplement her income as a certified laser technician and it not conflict with
PT,
her role as a physical therapist providing wellness
the
services?
two different hats. like you said.
They're two different hats. And so it is, the licensee needs to be very clear to not cross over from wearing one hat and putting on the other hat. And that would be like I said, that's a challenging work environment.
but in her second question, okay? 100% agree with you on the first question. You got two hats, be careful, okay? Second question, would skin rejuvenation be considered part of wellness practice under my current physical therapy license? So now we go to wellness.
Yeah.
If it's wellness,
Yes,
oh, don't forget, if it's wellness, you still have to do a screen, you still need a treatment plan.
like you said, you do burns, that's skin
Yeah,
rejuvenation.
however, what challenge us to do is if this is wellness, show me where skin rejuvenation or treatment of the integumentary system is prohibited in the practice of physical therapy and wellness.
Mhm.
So we say here, I don't say, we keep saying, we say, please note also that services and conduct outside the scope of the physical therapy practice. Are we saying that's what she's requesting is outside the scope
No,
of practice?
not at all.
No, okay, I just want to be sure,
That's just that, hey, FYI,
okay.
if you do something that's not physical therapy, just know
This is the disclaimer.
you could
Right.
have a conversation with us if a practice act violation occurred, which is probably unlikely, but I think that it's appropriate to say that there. It kind of leans towards those, you got a DUI, right? And all of those types of
Yeah.
components.
Are we given are we giving clearance? I see where we're giving warning and it's good warning. I like that. Are we making the statement clearly that these are the things that are prohibited? And your request is not prohibited, provided that when you do it in wellness, don't just think that when you do it in wellness, it's not physical therapy. It's still physical therapy, okay? And you still need to abide by those rules and that govern wellness. I'm not sure that we've answered the question that it's not prohibited.
As it's drafted, it doesn't answer whether it's prohibited. It says the answer to your question depends.
Right. So you don't put like wrinkles could be prohibited. They're like, hey, I'm coming to therapy, I need you to remove some wrinkles on my skin. That's not underneath wellness. Right?
I mean, I think the statement accordingly, the answer to your question will depend upon whether skin rejuvenation is being provided for wellness purposes as defined
Yeah.
in the act.
Right.
So that leaves it
That's
to,
the answer.
Pretty broad.
leaves it to the licensee to make a determination if the
Right.
services that are being provided, are provided under, the provision of wellness services as defined by the act.
So we don't need to spell it out to them.
No.
And we've defined what in the act, define the reference, to the statute defines, what the definition of wellness services is.
That's the answer to the question.
Okay.
Back to the Practice Act.
Back to the Practice Act. Great.
So,
Thank you.
yes, thank you. I'm happy with the response. I 100% agree with Phil about taking the "you" out.
Yes.
But otherwise I have no concerns or feel like we need to add anything.
Do we need a motion for that?
So the attorney is nodding yes.
Oh, go ahead.
No, you know better than I do.
Yeah.
Well, yes, you should have a motion to modify, the responses as drafted to remove, the "your" language. There are two places in the answer to the volume where it says practice, as well, physical therapy practice, one, like, three. And the answer to the second question, two places.
Second sentence and third sentence.
That's it. That's not
And also to add
the language about being mindful.
that you could be requested, that you need to practice what's in your competence and have the education and training. And should this matter come before the board, you may be requested to produce certificates. Be mindful of Rule 198 or not 197 that says that you maintain those certificates for 4 years. And I can,
Amend that part.
yeah, whenever you draft it, well, it'll go out. Do you all want it to go out with the board attorney's signature or with my signature? Or does it matter to you all?
What's pressing?
Mine,
Yeah.
my email. So I'll see it before it goes out, because it goes out for me.
All right, so to remind us how we handle these, questions come to the board every day, all right? What the board staff attempts to do is to reference the licensee to the appropriate section of the Practice Act to find the answer to their question. Our job is not necessarily to answer their question.
Yeah.
We like to point them to the answer, okay? And then sometimes the answer may be reference section, reference the rule, reference section so-and-so, and consult your attorney, okay? Make an informed decision. You're a professional. Our job is not to babysit people and tell them what they can and can't do. Is give them clarification, refer them back, and answering a question. So in the past, every time a question was answered, it was considered as a declaratory statement. We're not declaring anything. We're just trying to help this licensee get some clarity on an answer to a question. And so we're making reference to the Practice Act and then we move on. If it's not cut and dry and needs some input, as this one was, then it's brought to the board for discussion, and then we are now just approving the answer to the question. We're not making a clarification statement or a declaratory judgment or declaratory statement. There's processes for that.
I would add to that, that's a big picture perspective, but the board absolutely has a role in helping licensees understand the Practice Act and practice within the boundaries of the Practice Act and providing clarity. So I would
Yes,
just make sure
yes,
that
please,
the board has a very important role in that.
Elise, does that motion look okay?
Yeah.
We don't always have a motion to authorize me to respond to licensees. Is it okay that that's inconsistent?
I mean, I don't want to do anything that's inconsistent.
Okay. So I don't have to have a motion to be authorized to respond.
Okay.
So maybe asked Jessica to add that part. But let's just delete that part so that we're not inconsistent. Okay. So you had it right.
Sorry.
No, I just wanted to make sure with you before
If you require a vote, do we require a vote on this matter then?
we need a motion and a vote or no?
If it's consistent with your process to not do that, then we will continue with that process. So
Okay.
the purpose of the discussion is for the board's input for the executive director to issue a response.
Okay.
So that's,
So it's completed. So we don't need a motion.
What was the original motion?
She said move to modify the response as drafted by the
No,
board
no,
attorney.
from the last board meeting. So we made a motion.
Oh, y'all
to-
moved to, move this to unfinished business to allow the attorney and the executive director to draft a response to be reviewed at the next board meeting. Okay, so no need for a motion.
Okay,
We understand what needs to be done.
are we ready for, to move back to, education?
They're here.
Yeah, here, okay, great. All right, so we'll move out of unfinished business. And we'll move, to special program, a presentation about PBI education. Yeah.
We take breath.
Can we take a 5 minute bathroom break?
Yeah.
All right. It is, 2 minutes to 10. Get back together at 5 after.
Yeah, we covered a lot of this.
You may need the services of a physical therapist.
Yes.
Need it while we're in recess? Yes, I think. Thank you. And I am going
Jesus. There we go. Let's
All
try
right.
that.
Catherine and Casey, I'm sorry we had you on mute. We have introduced you. If you would, please introduce yourselves and you'll have the floor. Thank you and welcome. Thank you for being here.
Of course, thank you so much. It's our tremendous privilege to be here. We really appreciate the invitation. So I am Catherine Caldicott. I'm the medical director for PBI Education. My clinical background is in internal medicine, but I actually chose to stop doing clinical practice more than 20 years ago to really focus on ethics and education. That was started out in an academic setting, but I moved over to the world of remedial education in 2007, and I've been doing pretty much nothing else besides that ever since. If some of you were at the FSBPT meeting last fall, I presented there, and you'll recognize some of today's content. But I do a fair amount of public speaking on behalf of what remedial education is, how it works, who can be remediated, things like that. I happen to teach PBI's Boundaries course, the Ethics and Professionalism course, and the Civility and Communication course. And I'll let my colleague Casey Cleary introduce herself.
Sure. Thank you, Catherine. Good morning, everyone. My name is Casey Cleary, and I'm the project manager at PBI. I work with our referring entities, so state boards, hospitals, medical schools, PHPs, on making sure they have everything they need when they send a licensee or an employee to a PBI course. So I work with them on all of the pre-course assignments and referral documents. I work with them on post-course reports, status checks, things like that. And then I also work with any organization, whether that be a state or a hospital organization, on preventative education. So I help them get the education to their employees or licensees in a wide scale setting if they are looking for that preventative education. And then I also partner with faculty on the live courses. I'm a proctor in those courses, so making sure that the attendees in the course are meeting the participation standards. So I help the faculty out with that. So that's my general role at PBI.
So with that, I think we'll go ahead and get started. I'm going to share my screen. Do I have permission to do? It looks like I've, whoops, let me just fix the border here for a second. And then you all should have received a PDF version of these slides. And we also sent you a handout in advance as well. But so let's just get started. So we are talking today about professional boundary violations in physical therapy. And we're going to cover the factors that increase the risk of sexual and non-sexual boundary violations among PTs and also PTAs. We'll talk about the range of harms that befall patients. Oh, and I use the term patient. I noticed that in your discussions, you sometimes say client or consumer, but for consistency's sake, I'm going to use the term patient. So what are the range of harms that befall them and others who are at the receiving end of boundary violations? We'll talk about how the heterogeneity among boundary violators impacts a regulator's approach to these licensees. And then we'll also talk about how incorporating various tools into your existing processes can elevate licensees' accountability and bolster their adherence to proper professional boundaries throughout their careers. So let's just start by thinking for a minute about what professional boundaries do. Well, professional boundaries define effective and appropriate interactions between professionals and the public they serve, or the people they work with or teach. And they also exist to protect both the professional and the patient or the other person involved, as well as their professional relationship. Here's a quotation that's adapted right from the Model Practice Act for Physical Therapy. Boundary infractions are committed when the act results from the exploitation of the trust, knowledge, or influence of emotions derived from the physical therapist-patient relationship. And boundary violations are really quite wide-ranging. Here are some examples: texting, emailing, or social media communication with patients about non-appointment matters, excuse me, dual relationships with a patient or a third party. And by that, I mean The primary relationship would be clinical, but then the extra relationship, which is why we call it a dual relationship, could be social or romantic or financial or an employment relationship or a familial relationship. There could be the exchange of gifts or money, could be treating family, friends, or coworkers, inappropriate touch, the use of inappropriate humor, supervisory lapses, and oversharing of personal information. I do use the term violation throughout. Some people prefer to make a distinction between boundary crossings and boundary violations, suggesting that crossings are not as harmful as violations. And that may be true, but although harms may be relative, they are still harms, and it's important not to lose sight of that fact. All right, well, how do these things happen? In other words, why do smart, well-meaning, highly trained and skilled physical therapists and PTAs who should know better and often do know better, why do they go off track like this? In other words, how do boundary violations occur? Well, we do have a premise that everyone, without exception, has the potential to commit a boundary violation. It doesn't matter how smart you are or how good your intentions are or how skilled or accomplished you are. So then why do only some licensees commit boundary violations? And why do they do that at the time and place and the way that they do? Well, there are a lot of different reasons for that. One is a lack of training about professional boundaries, a lack of formal training right within their programs, but even sometimes a lack of good role modeling in professional boundaries. And we hear this time and time again, that folks wish if they had only learned this either in school or early on in their careers, they might not have gotten into trouble. Another reason is poor communication. So that could mean the tone of voice, or not respecting physical space between people, or the inappropriate use of humor, or misunderstanding or minimizing their professional role, especially in a hands-on profession like physical therapy. Now, people do misunderstand things, and boundary violations are committed when someone knowingly or even unknowingly crosses the emotional, physical, spiritual, or sexual limits of another person. Another reason why people commit boundary violations has to do with the concept of parallax. Now, this is a concept that comes out of astronomy, but it means the effect whereby the position or the direction of an object appears to differ when viewed from different positions. So that position could be a professional position, or a position in the power dynamic, or a position in attitude or sensitivity based on one's prior experience. So in other words, it's kind of a fancy way of saying perspective. And I'm going to show you this little cartoon. It's a depiction of an old Indian parable about blind men touching an elephant for the first time. And this is meant to show the limits of perception and the importance of complete context. So each of these characters in the cartoon believes their perceptions are really the truth. One person touching the leg thinks they're really touching a tree. Somebody touching a tusk thinks they're touching a spear. Somebody touching a tail thinks they're touching a rope, and so on. So they all believe that they have the truth, but none of them agree with each other. So we know that things look and feel different from different perspectives. And the perspectives have to do with your station, your role, your past experiences, and your own personal context. So this could explain a physical therapist, owner of a practice, who shares inappropriate images or jokes in the office with their employees. The owner believes it is all in fun, but others may be offended or possibly even traumatized. Another reason why people commit boundary violations has to do with something called inattentional blindness. And this is a term that was coined by Arian Mack and Irvin Rock in their book of the same name. And what this means is when it simply becomes impossible for one to attend to all the stimuli in a given situation, then a temporary blindness effect can take place as a result. So that is, individuals fail to see objects or stimuli that should have been plainly visible or audible or discernible, but they're unexpected and quite often they are salient. So here's an example. You're driving your car and you pull out into traffic and you don't even notice the person on the bicycle or the motorcycle coming right towards you, and you almost hit them because you weren't looking for them. You were only looking for cars. So that's a great example of inattentional blindness. This could explain a physical therapist failing to notice that their patients felt uncomfortable during massage and myofascial release, or a PTA failing to notice that a patient was becoming more smitten with her. Another reason why folks commit boundary violations has to do with something called a cold state or a hot state. So the cold state is kind of like what we're doing right now. Just sitting and thinking about something rationally, calmly. It's also like when you give an ethics test to someone and you ask them to write an essay about the dilemma that's posed. What is the right thing to do here? What should the professional do in this situation? And they're sitting because they're just in a cool state, writing an answer. All of their thoughts are accessible to them. They are very rational. They're not in the heat of the moment. But in the heat of the moment, everybody gets into what is called a hot state. And that's emotional and immediate, when decisions must be made quickly and when emotions are heightened or unsettled. The concept of hot and cold comes from a really interesting book called Predictably Irrational, written by Dan Ariely, who is a professor of behavioral economics at Duke. His work explains how expectations and emotions, perceived norms, patterns, and other invisible, seemingly illogical forces skew our reasoning abilities. This supports our premise that everyone has the potential to commit a boundary violation. And it answers the "what were they thinking" question that I bet you all ask yourselves when you read complaints and you interview licensees and you wonder how on earth it was that they were able to do whatever it was that they did. Well, the answer is that they were thinking, but they weren't thinking rationally. Now, in Professor Ariely's research, he had study subjects take the same test, first in a cold state, and then later they took the same test in a hot state. So in a cold state, these are smart, rational people, and they answered questions in one way, believing they understood themselves and their preferences and what actions they are capable of. But then when they got into a hot state, these very same people answered the very same questions very differently, showing that they underestimated their reactions and they could not predict the degree to which emotions would change them. So again, everyone has the potential to commit a boundary violation given the right set of circumstances. So based on this, let's look at those circumstances. In other words, what increases someone's risk of committing a boundary violation? Well, there are things that we happen to call risk factors. So these are external to the licensee. For example, the physical therapy profession itself is a risk factor because it's a hands-on profession. And physical therapists and PTAs are desensitized to touching because you do it so often. The practice location could be another risk factor. For example, providing home care or being in a solo practice or being alone with a patient in a hospital room. So all of these settings suggest a lack of supervision and a lack of accountability. The patient population could present a risk factor. There are certain patients who are particularly vulnerable. We often think of children and the elderly as being especially vulnerable, but also patients with a history of trauma. And you may or may not know, but the prevalence of trauma is incredibly high among the population in the US and in actually worldwide. It's estimated that about 70% of adults in the US and Canada can say that they have experienced at least one traumatic event in their lives. Isolation is another powerful risk factor. It could be professional or personal or geographic isolation. A lack of a chaperone around is a form of isolation. And then, of course, a history of prior professional problems. That is also a risk factor for getting into trouble. There are other reasons why people commit violations. And these we call vulnerabilities because they are internal or intrinsic to the physical therapist or the physical therapy assistant. So it could be their personality type. For example, they might really have an insatiable desire to be liked. They want to be a nice guy. They can't say no, often in every area of their lives, not simply in their professional practice. They could be conflict avoidant. They might see themselves as a savior or a rescuer. Perhaps that comes from how they were raised, that they put themselves in that role. Again, a history of trauma. Now, the literature supports a link between the trauma of childhood adversity and subsequent professionalism difficulties, particularly boundary problems, in physicians and trainees. But I believe there's no reason to think that physical therapists or physical therapy assistants are immune from those effects. And we know from more than 20 years of experience teaching remedial courses that a large number of our licensees have trauma experiences from later in life that were instrumental in their professional problems. Other vulnerabilities include relationship problems, illness, whether it's in themselves or in a loved one, unmet personal needs either from the present or the past, and poor developmental experiences with boundaries. You heard me already mention accountability. Violations also occur when there is inadequate accountability, like supervision or peer review or consultation. Lack of policies, such as office policies about how to communicate with patients or not seeing patients after hours, or personal policies having to do with not giving out personal information or their phone number or their email address. Even if there are policies, some folks don't adhere to them. And then finally, practice guidelines may be lacking in terms of informed consent or positioning or draping. There's another factor why violations occur, and this is something we call resistance. It's a lot like a defense mechanism. So these are things where the licensee may realize on some level that what they're doing isn't quite right, but they use denial or rationalization, or they get defensive, or they blame somebody else, or they use all sorts of justifications for their conduct. And then finally, a catalyst is something that propels a person who simply has the potential for committing a boundary violation to actually committing the violation. So it could be a person who pushes their buttons, could be a crisis at home or at work. It could be a life transition, and they don't all have to be bad transitions. They can be good transitions as well. Think about relocating to a new town or city, moving into a new home, building a home, starting a new practice, but also the loss of a job, the loss of a loved one, becoming an empty nester. All of those kinds of transitions can be quite destabilizing and act as a catalyst. It could also be a trauma experienced or a loss. And I think I'd be remiss if I didn't mention COVID, which certainly is for the most part in the rearview mirror now, but we have so many licensees who have experienced COVID as certainly a crisis, a transition, a trauma, and a loss. So I said earlier about the distinction between a boundary crossing and a boundary violation, and I want to submit to you that lapses do occur along a continuum. There is a spectrum of severity, and major violations are almost always preceded by lesser misdeeds. And these lesser misdeeds you might even refer to as red flags, but they could also include grooming behaviors. So let's take a look at some of the harms that are caused by boundary crossings and violations. Certainly there are harms caused to the person on the receiving end of the action. Think about the confusion that occurs when a patient does not know whether the person they trust with their care is their physical therapist, or their friend, or their employer, or their lover. They may blame themselves for the boundary violation, especially if it leads to a loss of the clinical relationship. They may also question the trustworthiness of the physical therapist and then extrapolate that to others so that their capacity to place their trust in others is diminished. Their capacity to hope for improvement in their condition wears away. It may erode their will to get better or to become more functional. They may lose the trust in future physical therapists, in the profession itself, or even in the healthcare system. They may participate less in their own care. And some lose their trust in any physical therapist they may need care from in the future, or they lose their trust in the physical therapy profession as a whole. Again, extrapolating from their experience. They may feel shame, embarrassment, humiliation, and especially if whatever happened became public on social media. There's also harm to the second parties. Now, who are these people? Certainly anyone who relies on the person at the receiving end of the improper conduct. And also the folks, so those would be their family members or their close friends, their work colleagues, their neighbors, but also folks who rely on the physical therapist or the PTA. So it could be other patients, again, their family members, work colleagues, and students of the offending physical therapist. There could also be an abrupt termination of care, a sense of betrayal and bewilderness, loss of income of employees, and loss of financial security for their families. And remember that those parties, so these second parties, often lack resources that will help them process their experience. And then there are third parties. So who else is harmed? Here we're talking about tarnishing reputations, legitimacy, and the authority of peers, institutions, and even the profession as a whole, especially if the boundary violation has been egregious or has received media attention. And then harms directly to the physical therapist or the physical therapy assistant. Could be the loss of job, their loss of reputation. I didn't even put loss of licensure up here, but that's certainly a consideration, or at least an impact on their licensure. Psychological distress, shame, embarrassment, humiliation, guilt, damage to their personal and or their professional relationships, and then financial costs from loss of income, but also attorney's fees, counseling, relocation costs, and other things. All right, let's talk about the boundary violators themselves. And they are a heterogeneous group. This very heterogeneity may affect your approach to them. So if you were at the FSBPT talk, you heard me present some of this, and I'm going to go through it kind of quickly. But this area really was developed mostly in the 1990s with research on male members of helping professions, such as doctors, counselors, lawyers, ministers, and teachers. And they were only sexual boundary violators. But what was interesting is that when they were folks were counseled and studied, that the folks doing this research recognized that these boundary violators used different patterns of exploitation. And they were able to see some commonalities in some of these patterns, so they lumped them into different groups and called them typologies. Other folks working in the world of remediation recognize that these typologies applied much more broadly to non-males, to members of other helping professions, and to folks who violated non-sexual boundaries. So I want you to know about the typologies because these violators are not homogeneous, as I said, and they merit a more tailored personal approach and a regulatory response. But we also teach our licensees in our courses about the typologies because getting into trouble is a very isolating experience. And it's helpful for course participants to see these typologies because it shows them that they're not alone. So here's the list of the 6 typologies identified by Irons, Schneider, and Gabbard. And just so you know, I did rename a couple of them to make them more inclusive, the naive royal and the dark magician. So I'm just going to go through them quickly one by one. So the wounded healer is a very, very common typology. This could be the doctor of physical therapy who owns their own practice, who I referenced earlier when I was describing parallax. So they need to be liked by everyone, and they try to achieve this by joking around with their staff and colleagues in the office and giving impromptu massages during the workday. Their jokes are considered insensitive and inappropriate and even offensive by some, and the massages are unwelcome and also considered inappropriate, intrusive, and even creepy. And eventually you may receive complaints about this physical therapist. There's the naive royal, and this could be an early career physical therapist who had been experiencing marital difficulties and began an extramarital affair with someone they knew from their gym. As I go through this complicated scenario, think about all the harms that occur along the way. So months after the affair broke up, the former lover reached out to the physical therapist to see if they could provide a massage for upper back pain from lifting weights. And during one of the massage appointments, the physical therapist just happened to mention that the group practice is struggling because of inefficiencies. The former lover persuades the physical therapist to hire them as an office manager. If you think back to when I was talking about dual relationships, this is actually an example of a triple relationship. So the love relationship first, then the clinical relationship, and now an employment relationship. As office manager, the former lover alienates the rest of the staff and some of the patients. The physical therapist eventually figures out that the new office manager is diverting funds from the practice and fires them. The office manager / patient / former lover files a complaint with the regulator alleging sexual harassment. So harms have come to the patient, the physical therapist's spouse and marriage, the original employees of the physical therapist, some of the other patients, the practice as a whole, and the reputation of the profession of physical therapy. Next, we have the self-serving martyr. And this might be an older physical therapist who started their own practice and has never hired enough partners or staff to assist with the workload. They need the loyalty and approval of all their patients to give them a sense of self-worth. But being so busy means they are often rushed and fail to explain what they will be doing and why. They don't pay attention to their patients' body language or facial expressions, or develop an awareness that many patients and staff and students have a history of trauma. I alluded to this when I described inattentional blindness. If you have a male licensee like this who uses massage and myofascial release in his practice, it will not surprise you when several female patients file complaints alleging sexual assault. And I don't mean this to be a heteronormative example, it's just that it's a pretty common scenario. Then we have the lovesick one, and this could be a doctor of physical therapy who specializes in youth sports injuries. They engaged in a friendship with the parent of one of their patients when they recognized the two of them had something in common. Right away, they felt a connection. The physical therapist falls in love with the parent, and this led to a sexual relationship with the parent. Now think about the harms that come to the young patient. So the young patient isn't involved in the love relationship, but still experiences harms. The young patient may become confused about whether the physical therapist is their treating clinician or their parent's new love interest. They may wonder whether the physical therapist is interested in their recovery or whether they were simply a vehicle to facilitate the romantic relationship, which might cause them to question the trustworthiness of the physical therapist or all physical therapists, and possibly even all healthcare professionals. The patient might wonder whether the physical therapist has their best interest at heart. They may also feel trapped. If the therapy isn't going well, they may feel that they can't tell their parent they want to stop or go to a different therapist. If the therapy is going well, they may not feel they can be discharged because that might put an end to a relationship that seems to make their parent happy. So this can get very complicated. We next have the masochistic surrenderer, and this might be a physical therapist who provides home PT. One of their patients is elderly, whom they are rehabbing after a knee replacement. This patient asks for assistance with other tasks, like bringing in the mail, taking out the trash, picking up prescriptions, heating up their dinner. The patient even asks the therapist to stop over on non-therapy days simply to visit and chat. On one of those occasions, a family member showed up unexpectedly and found the physical therapist stealing the patient's opioid pain medication. And then finally, the dark magician. To summarize, the people who fall into this category have sociopathic tendencies. So this could be the doctor of physical therapy who supervises DPT students and holds one-on-one demo sessions after hours. The students complain of inappropriate touching. This physical therapist may have had a pattern of this over the years, might even engage in antecedent grooming behaviors, such as mentoring sessions, where they provide career advice, which would then raise concerns for predation. All right, well, you may be wondering, can boundary violators be remediated? The answer is yes, almost all of them, with the often exception of the dark magician type. But I just want to digress for a minute to talk to you a little bit more about what it's like to interact with these licensees in ways that you don't have an opportunity to interact with them. If the licensee's infraction is egregious, say it's a boundary violation or it's financial exploitation, their conduct may be particularly distressing and perhaps even triggering for you as regulators and investigators. But clinicians who have abused the trust of patients or coworkers or supervisees or students, and by this I mean licensees who fall into the different typologies, again with the likely exception of the dark magicians, that those licensees may be incredulous at how they became capable of betraying that trust. Think back to what I told you about Professor Ariela's research, that when in a hot state, people can act in ways they never thought themselves capable of. So when boundary violating licensees confront the reality of what they did, many ask themselves some very deep, dark questions. It's important for you to know that licensees like this can be at risk for suicide. It's not unusual at all for the issue of suicide to come up during remedial boundary course discussions. And why am I telling you this? Well, first, to give you a perspective that you might not otherwise have, and second, to recommend considering how a more compassionate approach toward licensees may improve outcomes. Now, by being more compassionate, I do not mean making excuses for bad behavior or being lenient so that your sanctions do not fit the seriousness of an infraction. Rather, more compassion leads to deeper investigations, which lead to greater understanding, giving you additional context that can be key in guiding your disciplinary action. I understand it can be difficult to find compassion for licensees with particular kinds of wrongdoing, but a compassionate approach will more fully attend to their needs in terms of remediation, and therefore may result in greater prevention of recidivism and greater protection of the public. So what are things that you can do that will fit with existing processes? And that's what Casey is going to talk about in the next set of slides.
One place to start with impactful regulation is to broaden your investigations, assuming it is permitted by Louisiana law. And all of these are also listed on the handout we sent to you ahead of time, so you do have them to reference back on. If you broaden your investigation, you can increase your potential for discovering patterns by reviewing previous complaints. And then if you discover patterns, it gives you the opportunity to then interrupt them early. You may uncover underlying vulnerabilities that could lead to future misdeeds and can guide your choice of sanctions. If the situation is one of sexual misconduct, then a trauma-informed investigation would be appropriate. Trauma-informed investigations require specialized training for investigators, board members, and staff, as complainants' accounts in cases involving trauma can differ from other kinds of cases. Remember that some licensees have their own histories of trauma, whether it was from childhood or military service, some other reason, and that history may be what underlies their professional misconduct. If the investigation reveals a high probability that sexual misconduct has occurred, then you're going to want to send that person to receive a diagnostic evaluation. A diagnostic evaluation will be able to assess the behavior, identify contributing illness, impairment, or underlying conditions, uncover any long-standing maladaptive patterns of inappropriate behavior, and make treatment recommendations. By the way, those points are from the report and recommendations of the FSMB work group on physician sexual misconduct, which was adopted as policy in May of 2020. So what if you've previously mandated education, but the education didn't quite take and you're dealing with a recidivist or with someone whose conduct is worsening over time? Then you'll want to use intensive remedial coursework. Now, choosing the correct course is very important. The course should have a content versus process approach, and that means that the participants are not just viewing slides and content, but the course should get deep into the how and why a participant may have gotten the situation in the first place and committed the violation. Timing and immediacy matters. This is an expression we have at PBI. It means requiring that the licensee should complete coursework within a short time frame, say 3 months. That's what we see pretty often, which accomplishes several important goals. It accelerates improvement in practice. It reduces the risk of additional boundary violations that might occur before the course is taken. It increases the impact of regulatory proceedings because as the length of time between the boundary violation and the remedial education increases, the connection between what was done and what needs to change becomes attenuated. It also facilitates change. The longer the delay in remediation, the more entrenched the licensee's resistance becomes, meaning their use of denial, rationalization, or other blaming. Licensees are more receptive to learning and changing when resistant thinking has not had the opportunity yet to become entrenched. The course should also have adequate rigor and accountability, which I'll talk more about on the next slide. These features of remedial courses below demonstrate adequate rigor. A safe learning environment with a confidentiality policy so that they feel comfortable sharing. A small group with designated faculty. Restorative and transformative approach and not punitive. Telling of the story or the reason why they got into trouble is required. Peers in the group model taking responsibility. For expectations of participation in assignments, I want to explain a little about how PBI does it, but there are other reputable course providers out there, but you should be looking for these types of features. So we do a technology pre-check meeting. This ensures that they're comfortable with the virtual format. They understand the expectations required of them during the course. Adequate pre-course assignments and a course proctor, which I mentioned earlier is one of my roles at PBI. And the proctor will partner with the faculty to supervise participation, engagement, attendance, multitasking, and that they actually are paying attention. And then an education plan with action steps to apply in practice. This is an entire exercise in accountability. So you likely stipulate in orders that the licensee must successfully complete the remedial course or multiple courses, but successful completion suggests that once the course is passed, the remediation has been accomplished. But remediation and relapse prevention are a long-term process. A person may have completed the course and passed, but they have only just begun their remediation journey at that point. You can extend your regulatory reach with long-term accountability. That could include on-site monitoring or a peer assessor, periodic check-ins with a compliance monitor, mentoring and supervision, personal coaching, or a long-term accountability course. A longitudinal follow-up course normalizes the remedial process into lifelong learning. And again, remember that everyone is at risk. So lifelong learning can act to destigmatize the experience of having gotten into trouble. Some additional things that you can order using the heterogeneity of boundary violating licensees as a guide is peer support groups, decrease isolation through practice setting requirements, restrict practice setting or type, restrict working hours, or chaperone use, which some jurisdictions do choose to order. And here I'll turn the floor back over to Catherine to speak a little bit about recidivism.
Thanks, Casey. I would imagine that many of you are very interested in the recidivism question. This is a question you get on a regular basis. And it might or might not surprise you that recidivism is very hard to study. Just as a bit of shameless self-promotion, I did write a paper on why it is so hard to study. It's published in the Journal of Medical Regulation. I think it was in 2023. But just a couple of examples is why is sometimes people are licensed in multiple states, and the reporting of professional misconduct in one jurisdiction doesn't either get reported promptly to the National Practitioner Data Bank, or it doesn't get shared through FSBPT. And so they're able to continue to practice and practice inappropriately elsewhere. Sometimes people are just lost in follow-up. Sometimes people will get in trouble for one kind of infraction and they might be remediated, but then they get in trouble for a different kind of infraction. So does that count as recidivism or not? So there are an awful lot of reasons why it is difficult to study. Nevertheless, I want to show you a little bit of data. So this was a poster presented by some of the folks from the Federation of State Medical Boards. The lead author is Aaron Young. And they looked at roughly 4,000 allopathic physicians in the US over a 5-year time period. And they noticed that those who had continuing medical education courses as part of their disciplinary action, as part of the terms and conditions of whatever the disposition was, and that was not quite 1,500 of them, were less likely to receive additional sanctions within 5 years compared to the others who did not have CME as part of their disciplinary action. This is another small study, and it's one that we conducted ourselves. And we only looked at licensees from one state because that state had a very transparent, easy to navigate website that posted everything promptly, including accusations, not just disciplinary dispositions, but even posted accusations. And we looked at them over a 5-year time period as well. Our total sample was 322. We had to exclude a number of folks, so our final sample was only 210 people. But what really distinguishes this study is we followed these folks for a period of between 6 and 11 years. If you look at the recidivism literature, you will not see anything that comes close to that. The closest was the previous study I just showed you, which followed folks to 5 years, but most studies follow folks for a year or two. So we had between 6 and 11 years of follow-up of these 210 people. And in that time period, only 6 of them reoffended with exactly the same offense that they got in trouble for in the first place. And that's what we define as primary recidivism. Another 14 offended with a new kind of infraction. And we counted that. We didn't want to not count that because we felt like even though they didn't get into trouble for the original kind of offense, they still got into trouble again. And they should have known better. So we counted them too. And then there is that other category at the end. Those are folks who either voluntarily chose to relinquish their licenses, and we didn't have reasons for that. Some folks actually died. Some folks chose not to continue to practice for a variety of reasons. And so it's kind of a miscellaneous category. But anyway, I think being able to say that even though the numbers are fairly small, that not even 3% of our course participants reoffended with the same offense for anywhere from 6 to 11 years is noteworthy. All right, I'm going to turn the floor back over to Casey to wrap up.
Thank you. So examples from other jurisdictions, of course, prevention is preferable to reactive interventions. It may interest you to know what other jurisdictions and health professions are doing to prevent boundary problems. Here's a few examples of those. So this example comes from a rule developed by the Oregon Medical Board regarding the use of chaperones, not in mandated situations as a result of disciplinary action, but as a basic requirement. So this ruling was effective in July of 2023, and a licensee must offer a trained chaperone to be physically present for all genital and rectal exams and breast exams on patients who identify as female. The chaperone must always be able to observe the clinical encounter without distraction. Their presence must be documented. And if the patient declines the chaperone, the clinician could do one of two things. They can either defer the exam in question or they can proceed with the exam but document the absence of a chaperone. Because of the requirement that chaperones be trained, I thought you might like to know something about what that training actually involves. And the key topics in a chaperone training course include the chaperone's role and responsibilities, the techniques of observation, understanding customary draping techniques, proper documentation, challenging situations that might come up, objections to their presence, what to do if something seems out of the ordinary, and handling conflicts of interest with the physical therapist, and then boundary issues. In some jurisdictions and health professions where licensees are mandated to use chaperones, their regulators also require that the licensees themselves take the chaperone training course too, to understand what is expected of them and the chaperone. So other jurisdictions require preventative education in the areas of boundaries, but this may require legislative change. One example is the province of Alberta, which requires physicians to complete 2 patient relations modules covering boundaries and the slippery slope. We've seen a few of those models. They're excellent and they have very realistic examples. But I thought you would like to see an example of how the state of Georgia handles preventative education, and it's not just for physicians. We're pleased that the Georgia Composite Board is using one of PBI's online courses to satisfy these requirements. So the law was effective January of 2022. Dentists must take a course in the topic of professionalism, boundaries, and ethics. The required coursework for newly appointed board members of the Georgia Composite Medical Board within 3 months is sexual misconduct and boundaries and impacts of trauma and implicit bias. And then physicians are required to take the coursework in professional boundaries, sexual misconduct, and communication during intimate exams. The law in Georgia also applies to trainees as well. So a medical school's coursework must include education and training in professional boundaries, physician sexual misconduct, and communication during physical exams. That is the end of our prepared comments, but to summarize, we've talked about factors that increase the risk of boundary violations, the range of harms that result from those boundary violations, how heterogeneity among boundary violators impacts the regulatory approach, and tools you can incorporate into existing processes that will elevate licensees' accountability and bolster their adherence to proper professional boundaries throughout their careers. Thank you so much for having us here today, and we'd love to hear any questions that you have.
Any questions of the group at the moment for Catherine or Casey?
I have a question about, Catherine, about your research. Did you guys just look at licensees recidivism who went through a course? Or did you also, were you also able to look at individuals recidivism who did not go through a training course?
No, so that's the difference between what we did and what the FSMB folks did. So we looked only at people who came through our courses. So that sample, and maybe that's why the sample was so small, is that we were just looking at folks who took our courses.
Any other questions? All right, Catherine, Casey, thank you so very much. Appreciate it.
Thank you.
Thank you.
Thank you so much.
Yeah.
Very
Yeah.
helpful.
Take care, everyone.
Bye-bye.
Bye.
Their product. Yeah. More like an infomercial for their product versus like what they can offer, which is good to know, you know, and different stuff. They're gonna employ you to take it. Yeah. It was
Alrighty.
right.
Any discussions about
No,
that?
that's just, that's like, what you probably sell it to. Exactly. Okay.
All right, we'll get back on line with our agenda and we'll move to item number 5 on the agenda with our consent orders.
Last two. Board, last two board members.
Yeah, we've got a quorum. All right. All right, first. All right. First on the agenda is the consideration of the consent order for Adam Casborn, Casborn, license A7495, administrative case 2023-I-035.
Hey, you guys have a copy of that consent order?
It's being passed out right now.
Okay, perfect. I'll let y'all review it before we talk about it.
You're saying that this is Jen
Okay.
Rains, our attorney.
Okay. Thank you.
I think that's a a little bit bigger on me here.
Yeah, has everyone had a chance to review it?
I believe so. Y'all ready? All right.
And for those of you that I have not met, I am Jim Raines. I am a board attorney and prosecutor, so you'll see me in that role in the future. So welcome to you, those of you who are new members to the board. So let's walk through the consent agreement just briefly. So this individual, Mr. Casborn, we did our standard audit that we do for licensees and determined that he had not met all of the requirements for the 2023 audit. He was licensed in multiple districts. He was licensed in Texas as well as Louisiana at the time, and the courses that he took worked for his Texas license, but did not work for his Louisiana license. And he apparently did not realize that there were some courses with MedBridge, as I recall. He was a little bit difficult to reach at the beginning, but ultimately he had moved from Texas to Alabama. He works for the VA. Got in touch with him. We had an informal conference with him, and then we were able to work out this consent agreement and order with him pursuant to our informal conference. So it's fairly straightforward. It's just a reprimand. He's going to undergo education audits for his next 2 renewal periods after the approval of this consent order. If he's got any non-compliance with future audits, then he can be subject to discipline based on that. He's going to pay some reimbursement of costs that are fairly minor in this situation, $925.85. And then the rest of the terms of his consent agreement are fairly standard terms that we have in our normal consent agreements.
So I would ask that if we have any questions of him on the facts of the matter, that we can ask him that now. We then need to make a decision if we want to go into executive session to discuss the matter. We can discuss this in open session. We also have another consent order. We can gather the facts on those and discuss both of them in the same executive session, or we can come in and out for the 2. That's up to the pleasure of the board. So any questions on the facts of this issue for Jim before we start our discussion? Katie?
Jim, what was the status of his license in 2023? While we noticed he was in non-compliance.
He did lapse, but based on his failure to do, like what normally happens per the rule is if you don't have the proper continuing education, we deem your license as lapsed. So he would be deemed a lapse, but he did not bill for his services under his Louisiana license. He was located in Texas working for the VA. So we don't have, how we've had that normal billing issue with several folks this year where we've had multiple consent agreements where they were not licensed for a long period of time, but working in Louisiana. We don't have that here. So that's a difference between this one and say some of the other ones we've had more recently.
So what's the current status of his license?
Jim, his current status is active, and the lapse of the license, I just read through the facts. I don't think that's in the facts. I think that that's an old rule that the board changed so that we don't lapse somebody's license whenever they're non-compliant with CEs anymore. We revised Rule 199. So he did, whenever he renewed, his license remained active. And that was, so his license has not lapsed. He was selected for the continuing ed audit for renewing, and our rule no longer says, we're going to lapse their license for not, we go to this process where we determine what to do with non-compliance with an audit. So, and his license is currently active. He hasn't reinstated. Do you want me to double check us? I believe Stephanie's on the line as well to see if her recollection is the same as mine, without going through the whole file.
Wait, why'd you just use the word reinstated?
Because if his license had lapsed,
Oh, right.
to be active right now, he would have had to reinstate.
Oh, yes, right.
And so I don't
Remember that.
have any recollection whatsoever of a reinstatement
So
with this
he's been
individual.
active.
Yeah, I believe so.
So we have a
I think I'm right with this, but if I'm wrong, Stephanie, please chime in if she's still on Zoom. Because she sometimes remembers better details than I do. Was she on there? Okay, yeah, so I must not be wrong because Stephanie's not chiming in. So.
I have another question.
Sure.
Yes, ma'am.
So if he so chooses not to renew his Louisiana license for the next 2 renewal cycles and chooses to have a compact privilege instead, do we have any? Well, because he doesn't live in Louisiana. Correct.
He won't qualify for compact privilege because of this
Yeah,
order.
that's what I was gonna ask.
Okay.
So it would have to, but if he doesn't renew his Louisiana license for the next 2 cycles, no big deal, right? None of this applies. It's only if he chooses to renew his Louisiana license and he will no longer qualify for a compact privilege. That's correct. Yes,
That's correct.
Okay.
He won't qualify for one for, after this order is complete
yes.
for 2 years. According to the compact rules, he won't be eligible for a compact privilege. He'll have to get a license in other states where he'd like to practice.
And Charlotte, I do have a text from Stephanie. She said she can't unmute herself, but there is no reinstatement application in the file.
Yeah, I was in touch. And he's active, so yeah, okay, great. Thank you, Stephanie.
So.
Katie, I'm
so-
not sure I understood your question. Or I'm not sure that the answer and the question were the same.
So the consent order, the reprimand is that if he so chooses, it's his choice, right, to renew his Louisiana license in for the next two, am I saying that right? Hold on. For the next 2 renewal periods. So that'll be for 4 years, right? For the next 2 renewal periods, he has to comply with the continuing education audit, right? So if he so chose not to renew his Louisiana license, it's a non-existing point because he will not have to comply with this component, right? Because he won't have a Louisiana license. So then my next question is, if he were eligible for a compact privilege because he lives in Alabama, and I don't even know if Alabama is a compact state, but Texas is. So, or about to be, or whatever, Alabama is a compact state. So he could not renew his Louisiana license and just purchase a compact privilege. And I was just, if he would be eligible to do that, I was just gonna ask, do we need to include something in his consent order relative to that? Which I would also think the answer to that is no, that we couldn't do that, from my understanding that you can't regulate the compact.
So if he had a license in a compact member state and he waited, let's say he did not renew his license for 2 years. So he's expired in Louisiana, 2 years passes, and now he's eligible to participate in the compact. He gets a compact privilege to practice in Louisiana. He would not be required to comply with our continuing ed
Right.
with his privileges. He'd be required to comply with his Alabama
Yes,
continuing education. So
Yes.
we would not do an audit on his Alabama requirements.
right. But from what I understand from previous conversations, and maybe Jim, you said something slightly, like you added a layer to this. So if someone, whether it be his specific case or not, but if someone had a compact privilege, purchased a privilege, as a means of, avoiding disciplinary action, right, potentially, if they were eligible for compact, I know they potentially couldn't be. We could not impose Louisiana licensure requirements on a compact privilege. But Jim said something in a recent meeting, and I'm sorry, I'm bad at remembering.
And, point of clarification, you can't qualify for a compact privilege until 2 years after fulfilling
Okay,
the
got it.
requirements of your order. And in that case, I could get clarification, but his order would not be fulfilled.
Right,
His license status would remain reprimanded. Or actually, it wouldn't be a reprimanded, but I am not sure, because we haven't had this situation before, if somebody doesn't fulfill their order.
right.
How that timestamp works with the compact, but I will definitely make a note to ask that question because that's something that hasn't come up.
And I'm sorry to bring that up, you know, I think through scenarios to make sure that we're thinking through. If our intention is something, is there something that we're not thinking about because the world changes and maybe we haven't seen a scenario pop up. So that's all, sorry. So I appreciate you looking.
And I think that what this order accomplishes is that he's in compliance with what our board requires.
Right.
And so, yeah, so
But the compact and everybody else would be notified that his license, that he's been reprimanded.
if you all vote to accept this consent order, it will be reported.
Right.
Yes.
He won't even have access to purchase a compact privilege during that time that he's encumbered with that.
Okay, so he won't have access until what point?
I believe if I were, and you have to verify for me, but I think it's 2 years, like you said, after this is complete, like
So-
that order is completed.
But
So
what if he never?
What if he never completes it?
What if he never comes back and does
Then-
2 renewal periods? Will he never complete this consent order?
You don't know?
So what you're saying is that if he doesn't complete the order with the board, will he eventually be eligible for a compact
Yes.
privilege? Got it. So I think that's a question for the compact. My understanding, as long as that we have this individual encumbered, I think that's the proper word in this scenario, that as long as we have them encumbered, they're not eligible. Until that is removed from them, such as they've completed whatever requirements you have put on them, then they're not eligible. But that, I think Charlotte would need clarification from Jeff or Rich in this case.
So I understand what your concern is that if he chooses, since the individual is practicing in Alabama, if he chooses not to renew his Louisiana license and not comply with the terms of this consent order, will he be able to practice in Louisiana at some point in the future using a compact license?
Right, or be prohibited from, could he, yes or no, have a
After 2
compact?
years, right? 2 years?
After the completion of
Yeah.
the order.
Yeah.
So if it doesn't complete
So,
it. my
Katie,
understanding is
you're
it's
looking to see, are they trying to skip out?
Well, not only that, I mean, that's one side of it. The
Yeah.
other side is, are we prohibiting him from purchasing a compact privilege 10 years down the road, potentially?
Any
Any privilege from
in
any state, right?
As long as you're encumbered.
But by signing this, he's acknowledged that he's going to fulfill these requirements, right? As opposed to saying, I'm just gonna allow my license to lapse because I'm not coming back to this state. I'm good with surrendering that. And then if in 4 years he determines that he wants to try to come back, he could reach out for the compact. Would he be blocked at that time? But at this point in time, he's filling this out, signing this, acknowledging that he accepted these terms, right?
That is correct.
And then if he wants, then he would still be not at fault, but still showing that he did not comply with this process.
But he could renew his Louisiana license of signing this as well, right?
Yeah, right, right. But I'm saying he's acknowledged that this is the route that I determined, I'm not coming back. So by signing this, I would think that it would kind of bind him to the need to fulfill his requirements.
You're absolutely.
Yeah.
Yeah. I have a bad habit of overthinking sometimes.
No,
Because scenarios pop up that you just, but so I'm fine with the consent order. It was just more of a logistics, legal administrative question. I was just curious about.
Any further questions?
I have an administrative logistical question.
You're
For-
free to ask it, Charlotte.
Okay, so with the other boards, whenever they reprimand, because we historically haven't done a lot of reprimands, but this seemed appropriate to recommend a reprimand. Does the license status remain on reprimands until the completion of 2 continuing ed audits? Or is this like a reprimand that we report and their license remains active? Like, how does it work in practice?
Well, your license remains active. It doesn't prohibit you from practicing in any way. I equate it to kind of like a slap on the wrist, if you will, like, hey, do better next time. Make sure you don't do this again situation. So you certainly continue to practice as you always would. You're not deemed to have completed the terms of your consent agreement until he's gone through, like he's paid the fine, and gone through the 2 renewal cycles and complied with it.
So should there be a different license status than active, or that's how it's in operations, it's okay?
I would consider him still active. Yeah.
Okay.
He has discipline, still active.
So I have one more question. So, and it may just not be in the facts. So has he fulfilled his CEU requirements to remain active for his 2023 license status? Has he fixed that situation?
where he can't go back in
Hmm.
time and take coursework.
No, you can't, but
So-
there's a policy. Yes.
Stephanie might be checking the file right now, but I will tell you this, okay, because I did an analysis. Mr. Casborn had completed his ethics requirement, his jurisprudence requirement, and all 26 hours of clinical. The problem was that they weren't board approved in Louisiana for that year. They had been board approved in Louisiana in a different year. So had they been approved in that year, Mr. Casborn would have been in compliance. So as you can see in the order, you know, he wasn't responsive to the continuing ed audit, plus he had not done the job of making sure they were approved. Therefore, we thought an appropriate response was a reprimand to be more careful in the future.
He was saying they were approved.
Yeah.
You thought before they're approved this time?
Potentially.
Plus, he moved and didn't notify the board.
Right.
Right, so we don't need to be looking for people. We don't need to be looking for ghosts. That's a violation in and of itself. So in addition to his, you know, the continuing ed,
Not notified the board.
yeah, he did notify the board.
Then the, kind of follow up on your statement, the continuing education that he in turn lacked because of not being approved. Is that being redone of the hours that need to be done prior to his active status being
So,
cases of practice?
Without looking at the file, my memory doesn't serve me. I don't know if he actually went and did additional courses. That's why and Stephanie might be trying to respond, yeah, because she can't unmute herself. She may have a better recollection of if we received some certificates to make up for the problem. Because in the continuing ed audit, we notify you that you're not in compliance. And one thing that people do is they respond with certificates. Okay, now I am in compliance. Now what? In this case, we didn't get a response.
Sure.
And so, I don't recall that happening.
And because of the fact that he didn't treat, then there was no billing. Nothing needs to be going back and reviewed and stuff like that.
Right.
But at what point could he go back and bill and treat? Once this is signed and the fees are paid, is that basically his ability to now he's in good standings? Once this is agreed on, move forward, his fines are paid, and then he's in good standing. And then can he start treating and billing at that point in time?
He has an active license.
Right, he
Yeah.
does, but if
He can build, he can.
So even though he's
but if he billed and treated now without
getting CEUs.
without getting the CUs and still being reprimanded, can that, I mean, is that legitimate?
As Jim said, his current status is active, so
Correct.
reprimand does not prohibit him from
Okay.
practicing.
Good deal. I just,
So he's not prohibited from practicing, he's reprimanded, and as for lack of a better term, he's being slapped on the wrist.
sure, and so anything that he would have, if he did, right, if he did treat anything that would have been treated, could have been stood without any issue, since he stayed as active and not, he was just being, okay.
Is that, Jim, is that correct? In the event that we did determine that he had billed for services during the period of time where he was in non-compliance with the CEU requirements, because would he then be required to pay back any of the billing?
We are not ordering him to do that. And he didn't also,
Because he didn't.
he didn't do it.
Right,
He didn't
You
do it.
didn't do it.
Right,
Yeah.
it's right.
Right.
Just asking a question.
All right, again, okay, so the way
That
that
would be a
is,
different violation.
it would be unlicensed practice. So, yeah, when there's a violation of practicing without a license, that kicks in.
Understood. Thanks.
Right, and I'm not trying to bring up hypotheticals, add anything to.
We
the
need to look
conversation.
at it all. We need to
Just
look at
that if,
everything.
just trying to
Yeah.
figure out when he could
Yeah.
treat, if he fulfilled these requirements, then he's good to go forward.
Katie, do you have
Before that.
another point?
Yeah.
For that.
Okay, all right, so let's make sure our discussions are still based on the facts. All right, before we make a determination, we can discuss this in public if you'd like. If you'd like to move into deliberations, we can do so. And the choice of the board is to, in public or executive session, okay? I have no motion to go in executive session. We will handle this in public. So now we can move into discussing the order and any issues that we had.
And Stephanie responded and said that there are no additional CEs in the file, so they were not board approved that year, but he did complete all the requirements. He didn't proactively complete any more requirements, and we didn't request as a committee or recommend that he do that, so that I recall. So, okay.
So then for clarification, did not the the education that he performed in preparation for his renewal was not approved. Subsequent to being notified that those CEUs were not approved, he has not done additional CEUs to make up for the fact that the 26 hours that were not approved, he now has done 26 hours of approved education.
He has not produced any certificates to show that he would have done that. However, those courses were board approved in other years.
Yeah.
So they were PT courses. They weren't random, you know, like,
Podcasts.
or not related to the field of physical therapy, that they wouldn't have been board approved and considered.
Understood. The reason why they weren't board approved for that renewal year is, can you elaborate on that?
Because in order to approve a course, we need an application
From the vendor?
from either from the vendor or from an individual, and then it becomes a board approved course. So it,
So you could send your application before that and could have got approved?
he could have sent his application before that, either as an individual or reached out to the course sponsor, so. And it is strongly believed that, you know, typically whenever a course is submitted again, it's, unless something changes, it's approved, you know, for renewal. If it's been approved in 22, you can think it probably would have been approved by our board in 2023.
His assumption
Was
I don't know about his assumption. That's my assumption, that it probably would have been approved if the paperwork would have been
it
submitted.
would be reasonable to assume that the MedBridge courses, which were previously approved for continuing education,
was approved at that point.
were approved because they were previously approved. Okay.
And he was practicing in another state. He was licensed in multiple, practicing in another state, and in the state in which he was practicing, the courses were approved
In that state.
in that state. And so is the burden then on the physical therapist to check, are these courses approved in every state I have a license in?
I'd like to not confirm that statement. I don't know for sure that those courses were for his other renewal. I'm not sure with, and I don't know if Jim remembers this, or I know we presented this to the investigative committee.
Okay.
I don't remember that. All I remember us doing is looking at what Louisiana requires, because it's a CE audit. He got the jurisprudence, he got the ethics, he had all the clinical numbers, but some of those weren't Louisiana approved, but then we looked and they were approved in other years. And so we thought, okay, well, they are appropriate courses. They're just not approved for that year, but it's the same courses. I don't know that we looked to see what his requirements were for the other state, nor that he even submitted those for the other state. So
Well,
I don't believe we did that.
he represented that, Charlotte. So that's part of our consent order at number 8. It's
Okay, sorry.
Yeah, it's okay. During the informal conference, respondent advised the committee that the continuing education courses that he took from MedBridge qualified for credit toward his continuing education requirements in Texas, and he was unaware that they did not qualify in Louisiana. That was what he represented to us at the informal conference. We didn't make him produce like any confirmation of that, but I believe he's still active in Texas, and he's active in Texas, so presumptively he had the required CEs there.
Thank you, Jim.
Is there a precedent for this type of example?
So we have had non-compliance with CEUs, and we did an analysis to look at the differences, and that's how we came up with this. The other CE non-compliance examples were more harsh, and there were reasons for that. It was either no coursework was done, or coursework that was like, active shooter training at work, things like that, that really weren't really pertinent to the field of physical therapy. And I can go through all of that with you if you'd like. We might want to do that, I can do it in open if you want and go through everything that was similar with those cases versus this one. This one seemed much more like everything had been fulfilled, but those courses weren't approved in that year, and that's kind of a no-no, but also there was no response to the continuing ed audit as it should have been responded to after notices. And so there needs to be something more than just like, okay,
Right.
you can get into compliance. It was, you know, a little bit more than that.
Failure to notify the board.
Does he have to take approved courses now to get reinstated?
He's not lapsed. He's active.
Okay, so still,
So he'll
the
have
courses
to,
that they take were not approved, so
they weren't approved, right?
to get reinstated, I mean, he's good with those, and we have to take new courses.
So we did not put in the order that he would have to do any courses
That
for
would-
2023. However, for the next two renewal cycles, we're gonna audit him for the next two cycles to make sure that he's taking Louisiana board approved courses.
Okay.
You don't have to accept what we've proposed.
Okay.
So 199C basically says if they're not successfully in establishing compliance, right, or have an acceptable exemption, which is usually stated, that they may be subject to disciplinary action or required to take the exam again. So like, and there's varying severities of this violation that we've seen. I mean, if you look at our recent consent orders, there was one that somebody went years, two cycles without any, you know, CEUs, et cetera. And so like, so you have a spectrum. So it basically in the Practice Act says may be subject to disciplinary action, but doesn't have requirements set in the Practice Act. That's what I was looking for.
And then bear in mind, I believe someone said he did agree to this order, right?
Very
And
kind.
so he is promising the board that he will take these, because now that he's working at the VA, he could practice and stay at the VA and not have a license anywhere in any state. So I think that he's showing some good signs of good faith, that he's willing, in order to keep his Louisiana license valid, that he'll do what he should in the coming years.
Right.
Agree. Any further discussion? All right, so we are in open session. I will entertain a motion.
I'll move to approve the consent order for Adam Caswell.
All right, we have it's been moved by Lee. We have a second, second by Deidre. In reference to administrative case number 2023-I-035. We have a motion to accept the consent order as presented, and a second. All those voting in, let's have a roll call vote here, okay? Before we vote, do we have, being we're in public session, do we have any comments from the public?
If you're on Zoom and you can't unmute, raise your hand.
And Charlotte said, if you're on Zoom, raise your hand.
No hands are raised.
All right, no hands are raised, no comments from the public. If not, then, may we have a roll call vote?
Okay, O'Day Laverne.
I will last, please.
Oh, I'm sorry.
It's okay.
Danny Louie.
Yeah.
Adam York,
Yay.
Katie Britton,
Yay.
Phil Page,
Yes.
Deandra Narcisse,
Yay.
Lee Riley,
Yay.
O'Day Laverne.
Yeah.
The ayes have it.
The ayes have it. The consent order will be signed today. I'll take these back. All right. And we amended the agenda earlier in order to review the second case, and the additional consent order is in reference to Elizabeth Hale, or Haley, Haile, license number A107889, administrative case 2023-I-048. The consent order is being passed out as we speak. We would take a moment and read the facts. I'm sure.
Gentle.
That's 12th day of June.
Yes,
Thank you.
because. The other is active. Getting phone calls, getting to the corner, I think. That's why I wanted us to call, because I had a feeling this has happened one time. It's fine.
Okay, looks that everyone's done. Jim, would you discuss the facts of the matter, please?
Sure. So for those of you that are not familiar with it, when we have licensees that they have their background check, when there is a subsequent arrest of that individual in the state of Louisiana, we get what's called a wrap back report. So we get informed that they have been arrested. That comes through state police. So on this particular individual, we received a wrap back report that she was arrested September 18 of 2023. And in St. Tammany Parish, that was related to a DWI, possession of alcohol in her vehicle. We rated, what we do is we allow the individual the time to report under our rule 345B15. They've got 7 days within which they're supposed to report an arrest to us. She did not report it timely, so we noticed her of a board-initiated complaint relative to her failure to report. That was sent to her in November. She subsequently responded to it through her counsel and provided documentation related to her case going on in St. Tammany, that she was going through a diversion program there. Then in May, we learned that she had gone into a treatment program in Florida for substance abuse. And that was an inpatient program. It was fairly lengthy. And our customary practice is when someone is going through that kind of program, is we need to make sure that they are safe to practice. Our obligation is to the public, of course, to make sure that we have safe practitioners. And so that is why we have entered into this consent agreement and order. She is now out of treatment, I believe. And so we've got some requirements of her. So if you look at the order, her license would be suspended until she submits to a fitness for duty evaluation with a board recognized provider. And it's going to remain suspended until we receive a report that she is safe to return to the practice with what we call reasonable skill and safety to the public. All right, that's number one. Two is she's got to agree to follow, or she agrees to follow all treatment recommendations resulting from that fitness for duty evaluation. If she goes and starts seeing a therapist, treatment provider, then we'll get the records from them and verify how she's doing, that kind of thing. Once her license is reinstated, she will be on probation for a minimum of 5 years. And during that time, she's going to participate in our recovering physical therapy program. You'll hear us refer to it as the RPTP. And then there's all kinds of obligations that she has when she enters into that program. She executes what's called a RPTP participation agreement. And then she will be monitored through that program to make sure she's staying sober and meeting all of her requirements there. During that probationary period, the board can make unannounced monitoring visits. So those will occur. And then she has to reimburse for cost related to the monitoring. She's also got to report, this is number 6, basically those that she works with, she has to provide a copy of this consent agreement, and then they inform the board that they have received that. This is extended for any period of time in which she's not employed at least 20 hours a week. Okay. Relatively minor as far as partial reimbursement of cost. $725. She and her counsel have been very cooperative in this process, and basically have told us, she's ready and willing to do anything she needs to do to make sure she gets back and sober and back into the practice eventually when she's safe. The rest of the terms that we have here are just very standard terms in the consent agreement. Any questions about her situation?
Jim, O'Day here, her recent inpatient treatment, let's presume that she goes and she does our fitness for duty evaluation, and our fitness for duty evaluator says, you need some inpatient treatment. And she just got out of inpatient treatment.
So number
Then she needs to go back to inpatient treatment. So we are allowing our evaluator to determine the efficacy of the previous treatment, or at least the current status of where she is. Current status was fitness for duty. We're really gonna kind of ignore the treatment that she's had.
No.
I don't think they would ignore it, O'Day, but one important thing is that we have specific board approved providers. She went to a non-board approved provider. Now, we didn't know ahead of time that she was going into that program. And when we're aware that somebody is considering going into treatment, the first thing I tell them, or anybody from the board would tell them, is, okay, there's certain groups that we have approved to provide treatment to our licensees. So if you choose to go to an outside provider, that's on you. Eventually, when there's a fitness for duty evaluation, if they will look at what you have done, maybe what you have done would be compliant with what we would normally have somebody do, but that's really up to the determination of our evaluator. And that's why we have them. We're not, that's not really our expertise, that's their expertise.
Thank you. That answers my question.
Sure.
Any other questions of Jim? And again, is that privilege, the pleasure of the board to go into executive session to discuss, or do we wish to discuss in open session? Okay, hearing no motion to go into executive session, we will continue in open public session for the discussion of this matter.
Move to accept the consent order as presented.
Second.
We have a motion and a second. Yes. All right. We have a motion by Katie, second by Phil, that we accept the consent order as presented. Any comments from the public in reference to this matter? And is the respondent on the call, the Zoom meeting? No, respondent's not present. All right.
Oh, they waived their presence. I spoke to her attorney about it. He asked if they needed to be present for it, and I told them that this is a very standard consent agreement that we have had with other individuals in the same situation. So they chose not to appear.
Great. Okay. All right, we have a motion and a second on the floor. No further discussion. May I have a roll call vote, please?
Yes, Danny Louie,
Yay.
Adam York,
Vote yay.
Katie Britton,
Yay.
Phil Page,
Yeah.
Deandra Narcisse,
Yay.
Lee Riley,
Yeah.
Ode Laverne.
Yes.
The yeas have it.
The yeas have it. The consent is approved, and we will execute it today.
Thank you.
Thank you, Jim.
Thank you all.
All right.
Is it 6?
Yeah.
Cross that out.
Hmm? Yeah, thank you. All righty. It's in order. Okay, now let's back to our agenda, and we had moved around in the agenda. We will now be, have we completed unfinished business? All right. All right, new business.
I went to this. There you go.
It is 11:45. New business. We have quite a bit of new business at this meeting today. We took care of Mr. Marcus Houston, who was originally listed as new business. All right. Next on the agenda is the AG. The Attorney General has issued new maximum rates for attorney fees. Celia, one of our prosecuting attorneys, has requested that we honor the rate increase from $225 an hour to $350 an hour. Prior to 2019, we did not pay the maximum rate. Since 2019, with all of our attorneys, we have offered the $225 rate in order to honor the rate allowed by the AG's office. This is a significant increase, and it was not considered in our budget for our next fiscal year. If we honor this rate for Celia, we want to consider this for all of the attorneys on staff. And then our budget was based on actual dollars expected to be spent this year. And we may have to revisit our budget. And also Celia is going to be contracted for prosecutor services, which is the same service that Jim's firm is going to be providing to the board. So she will be an additional prosecutor. And she is currently on several cases that we have open right now, even though she's not in the room today or present on any of our cases today. Okay. So with that, any further discussion on this matter? Do I have a board motion? What's the pleasure of the board?
We need to make a motion to discuss, right?
Yes, we need a motion.
When you make a motion and then have a discussion, right?
Yes.
So I make a motion to accept the rate that she's requesting.
Phil has moved. Do I have a second?
Second.
All right, Danny has seconded. For discussion purposes, now this is open for discussion.
Have we made a counteroffer?
So we have not. No, I mean, to ask them.
Yeah, welcome to leave it. I'm not Cynthia, but
Yeah. So the rate is, the Attorney General, issues a maximum rate that you can pay attorneys.
Mhm.
The maximum rate for an attorney who has 10 years of experience was $225
Mhm.
prior to this change. I did, share the request
Mhm.
from Celia, where she, okay, great.
Yeah.
So, there was no counter. What happened is that after that board meeting where you all reviewed which contracts were going to be expiring in the next year and how much they were before, we looked at a chart and you said, yes, we have approval to enter into all these contracts. We then drafted up the contracts with the rate before
Mhm.
and, you know, however much it was. And Celia's response was, oh, the rate changed. And my response was, well, that's a maximum. And I didn't request to the board if we would change your rate from what it was previously. And she said, well, will you please submit that request? So that's where we are today. I didn't counter her with her or anything because I haven't talked to you guys about it.
Bear in mind, if her rate goes up, does the maximum amount of her contract change? It's still capped at,
She did not request that. So we, the contract, the way that we drafted it was a 1-year contract, not to exceed $100,000. Previously, she had a 3-year contract, not to exceed $300,000, and we kept the same rate. So it's basically the same thing, just, divided in 3.
right, so now we have in front of us a 1-year contract for $100,000. We're changing the hourly rate, so she'll burn,
Let's,
it's gonna increase her burn rate to get to a $100,000 cap. We're not suggesting that we increase the cap that we're paying her. She still has a $100,000
That's
contract.
what we budgeted for.
That's what was budgeted for, correct?
So we, enter contracts above budget so that we don't have to amend contracts if we find that we need more services.
Okay.
So the contract would be a maximum of 100,000, but next year's budget for Celia was closer to 25,000. Because she's only assigned to one case right now.
Okay.
And don't know what's gonna happen in the next year, but we've budgeted around there.
That's what makes the budget hard, is that you have no idea how many cases
Sure.
you will have
Sure. Good point.
every year.
Now, keep in mind with our attorney fees, when they're prosecutors, generally speaking, in 95% of the scenarios, we get our fees back. We get our costs back. Not in all cases. Because sometimes we get the attorney involved and there's not a fine, there's not a penalty, there's not a fee, there's nothing to reimburse, but we still had attorney expense.
That's a really good point, O'Day, because also the higher our expenses are, the more we're going to be requesting to be reimbursed
Sure.
for disciplinary matters. That was something that, I didn't think to put in the prep materials. Yeah.
Mhm. And then my understanding is if we change the hourly rate for one of these contracts, then we would consider changing the hourly rate for the remaining contracts.
That's my recommendation, would be to consider all of them at, at this time, rather than us coming back one after the other, because it's contract season.
Would the board feel better about making a decision if you had numbers in front of you and how it'll impact the budget? In terms of feeling comfortable approving a change like this?
That would give us more information to make it good.
Yeah. That would be my recommendation, is that we look at the actual numbers and how it
Right.
affects the overall budget. Which has not been done.
Would you,
I'm recommending, I asked if.
Oh,
people
okay,
would
I
be
know what you
interested
said.
in that data,
Okay.
but I'm recommending that we present the number data to the board to help them to make a decision. In terms of how, if this change happened, what that would look like in terms of the budget.
try to calculate the hours real quick, like the amount of hours you would have available versus if it was at a different rate? Would that be helpful? You know that there's gonna be fewer hours available.
So what you're saying is you're just,
What you getting for your money?
that you're just gonna do, you wanna keep, you would keep the budget number the same and just only let them work less hours. I'm thinking more like leave the hours the same and increase the budget, because the hours are the hours. I mean, that's what we need the attorneys to do what they do. And so we just need to make sure that we as a board have the funds to carry out the duties and responsibilities that we have. And if that means that we have to pay our attorneys for the amount of time that's required for the complaints that come through the door, then that's what we have to do.
Okay.
And we need to make sure we have the funds to be able to do that. So I would never suggest that we would decrease the amount of hours of what we need from our attorneys. That we just need to make sure we have the money to support the attorneys to do what they need to do.
Since it's the end of the fiscal year,
Mhm.
well, let me let y'all finish and then I'll ask y'all a question.
We think the attorney would say if you didn't agree with the 350, say 325 or 300. Would you think that'd be an issue, which they might not work with us anymore, or?
I didn't have a verbal conversation with Celia about this. I had an email. She did call me after the memo was issued and she said, we were amending her contract at the time because we have a criminal background check audit with state police every year, and they required that we amended all of our legal contracts. And she said, did you see this memo? Why don't we add this to the amendment and change my rate? And I said, yeah, I saw the memo. And I said, but this amendment's related to this. And so whenever I didn't address this at the time because I was in between something else. And so then whenever we issued the contract, she responded and said, oh, wait a minute, what about the rate change? And I said, oh, I didn't bring it up to the board yet. Let me bring it up to them. So, and the thing that, over time, before 2019, our rate, even though there was a max of 225, we paid our attorneys we had 2 attorneys, we paid one $100 an hour and one $150 an hour. And so the decision to go from that rate to the 225 was a pretty significant decision in 2019. It's been 5 years. Cost of living has changed, all of those things. And so has the maximum, but we used to not be at the maximum. And that's why whenever the memo came forward, I was kind of like, because we never really operated at the maximum anyway. I was kind of like, okay, well, it's changed. We can offer more in time, but I didn't think it was like an urgent matter necessarily. But now that we have the request, it's more urgent to discuss it.
Did it seem in conversation that it was open for conversation with her, or that it was just?
She's always open
matter
for
of fact?
conversation. She's always open. She would be, I know she likes working with our board.
Mhm.
Celia's worked with, for those of you who don't know her, she's worked with the state for a very long time and has experience with a lot of boards. She's very well respected. She does a great job. I mean, she's a wonderful attorney. So I think that even if we wanted to invite her over here and talk about it, she would, but I think she would be open and receptive to talk about things. I do think that because she has so many years of experience and because of the value she provides, she wants you all to consider upping it because she said, her private rate isn't even that. So.
I agree with Katie. I think we should just make sure that we have the financial means to be able to support our legal services. Because we can't predict, how often we'll need them. And, I would hate to be in a situation where we didn't have the funds to be able to support legal services and need legal services.
And our duty and responsibility as a board is important, and having strong professionals
Yes.
to support the board that are the best in the
Yeah.
state I'm very much in favor of ensuring that we have the best of the best to inform us so that we can make the best decisions possible.
Right.
And I feel very confident and comfortable with our current attorney staff. They've been remarkable. And I would like to ensure that we keep those particular attorneys on staff.
I would like to not suggest that we get into a nickel and diamond issue here. And not to speak poorly of anyone else, but you get $100 an hour lawyer,
Oh, yeah.
you get $100 an hour lawyer,
Right.
okay? I don't think we want $100 an hour lawyers here, okay? We like to pay our lawyers to the best we can at the top of the state pay scale, and we like to attract the highest lawyers that have experience in this, prosecuting and defending and giving our board advice. And practice administrative laws. We spoke last night. This is a specialty field. Not everybody is aware of that or competent to practice. So I think what's on the table is a motion to discuss this. I think I'm hearing that we want to revisit and to look at all of the fees. So do we rescind the motion? Do we amend the motion? What's the pleasure of the group?
I would like to make a different motion.
Okay.
So will that be a
Substitute motion?
substitute motion?
So I'd rescind the first motion.
Okay.
So, and before y'all do that, can I make a discussion on the motion that's on the table?
Absolutely.
Okay, so, we do have, like, we already have a signed contract from one of our attorneys, Amy Groves. And so we also, because fiscal year is ending, Celia's contract's gonna end, and we perhaps might need her services during the period of expiration. So, would it be okay to not make a decision on this motion and then perhaps amend the contracts to have a different rate if that's decided after looking at the budget, so we can go ahead and move forward with our contracts? And we can communicate that with Celia. Hey, they're taking it under consideration. They, we're gonna look at the budget, we're gonna do what we can, but will you sign this contract so we don't have a breach in services?
Yes, absolutely. Sounds exactly what my motion
I'll make
would
that
sound like.
Oh, I'm so sorry. I should have let you talk.
No, I'm saying I agree.
Okay,
I love
wonderful, wonderful.
Yeah.
it. You stated it much better than I would have.
Okay, so, we're just gonna, this motion's going to die and we will,
Yes, that motion has been rescinded.
okay, and then that's it. Cause we already,
We'll have to make your motion.
well, y'all already approved to enter into the contracts
Right.
at the last board meeting, so.
And we're gonna look at the budget anyway at the end of the year, and we will bring this data back to you guys to have a more informed
We'll
decision.
look at it sooner.
Yes.
Yeah, you mean at the end of fiscal year? Yeah,
Right,
yeah.
like it's time to look at it.
We're gonna look at
anyway.
it soon and
Yes.
get back to you guys. And
Yes.
so we can do a quick amendment on the legal contracts if it makes financial sense.
Retain all of our legal services, and if that requires paying them and changing their contracts, then we just need to.
Right, we can all
We'll
look
put that
at that
data
in
to rest.
everybody's, yeah.
Yeah, you can make sure we're budget for it.
You're gonna have to do it.
Yeah. we go back to the contracts.
You can ask the board.
No,
The question is,
Yeah.
are we gonna have to amend the contracts later? Potentially,
At a different rate.
if a rate changes.
That is
if I
correct. I
submit this
think-
through the state, through this, that's what the state's gonna have, so if you amend it later, then I have to go through the amendment process again through ProAct.
I'm sorry,
It's
I'm
fine.
not understanding the question.
It's fine, don't worry about it.
No, we
No,
do need to, we
okay.
have, we
For
think
the
we have a
administrative
simple,
component.
we
So
think we have a simple solution, but it might not be.
When you have a contract that goes, has to be approved through the state, it has to go through what's called ProAct.
Right.
It's their platform. So I have to submit the contract with the appropriate documentation. So recently, when Thurtle brought up we had to have amendments to our legal contracts for the Louisiana State Police requirements. They have to say certain things that have to do with the criminal background check process. That's just part of the audit that they found. They're like, we want these in your legal contracts. Everybody agreed. Okay, great. I had to go through the amendment process. It was a pain.
What did it look like?
The problem with it was just that I had to go through so many different, it took a while to get them back because they sent them back to me and said, well, you don't have this and this, or this needs to say this and this. So it wasn't super straightforward. I'm not saying this one wouldn't be, but I'm just trying to get clarification of what I can expect administratively. So if this is what y'all are doing, then I continue with what I'm doing right now. I get them approved, and then I know that down the line, I'm going to have to go through the amendment process again.
Sure.
That's all I wanted to know.
Okay.
And that's what it sounds like. Okay, good.
Any questions?
So would it help you if we made the decision to amend it today? Or is it gonna be the same problem if we amend it next month in the new fiscal year?
No, it's not necessarily a problem, like I said, it's just that it's required more steps is all. So it's not as clean, as far as for what I have to do, but the state isn't gonna care one way or the other, they're gonna review it all and what have you. And plus I already have one contract that's already partially through the review process with ProAct anyway, so, cause it's that time of year, like she said, that for those that are due, we're trying to get ahead of it so that we don't have to submit it late. Which you can do, but we try not to do, because you don't wanna lapse, so it's fine. I just wanted to understand what I was going to be expecting, like what I had to look to administratively in terms of that task.
And Charlotte, you and Celia will agree to, when she receives the information that we're gonna be looking at, the contracts, she'll agree to sign the contract in its current state.
I can't say for sure.
Okay.
I can't say for sure. I believe that if I tell her we're acting on this in good faith, she trusts me. And she'll believe that we are doing this and doing our due diligence, and that if we can put it in the budget, that we will honor her request. We have a great working relationship.
Okay.
So I don't think she would.
I don't want to jeopardize losing her services.
Absolutely, I agree.
So. I'll defer to your,
Right.
you know,
And I'll say she has 4 fewer hours. You know, it would be a smaller budgetary impact. Than if we did this, you know, with, let's say our other prosecuting attorney that's on most of the cases. Okay. So.
All right, done with that subject matter? All right. Next item on new business. We've received an inquiry about imaging from the APTA Louisiana and from an imaging center. You've received these questions ahead of time, but I put them, we'll put them up on the screen for us to review. And the next slides will show you the simple and quick answers to these questions. The slides following then will show you the cited citations in the statute and the rules that would support our answer.
Sorry. Which one are you doing first? The APTA?
Do the
one?
APTA question first, if you would. And we have that question. Do we need to like it read for the record? Can we submit the question to the record? All right. And so is this? the
You were
question
on the
that
right side.
Yeah, question you have on the slide, is that the exact question or have you paraphrased their question?
That is the exact, well, okay, I took out the 3 questions in a much lengthier statement that had references and, you know, so I took the 3 questions that were being presented to the board and I put up here what I anticipate based on what's in our statute and rules would be a response that we could point to for you all to consider and look at. Everyone did receive it ahead of time and we can put it as an attachment on the minutes if you would
Okay.
like.
And so for the record, I want this to indicate that we have a section in our statute and our rules of how to go about requesting a declaratory statement. This is not a question from a licensee asking for, as we had earlier today, it was just a question for the licensee looking for clarification. This is a declaratory request. So it was made in appropriate form, so therefore we have to then respond to it in an appropriate fashion.
Yes.
Okay, so in the question, the question cited multiple references as to the background of the question. And references were to the special interest group of the APTA in musculoskeletal imaging. It came from the orthopedic section, came from the House of Delegates. There was references to CAPTI in the educational program. There were then references to by the APTA. There were references to the Federation. There were references to the Department of Defense. There are references to the VA, and I'm missing one. Yes, okay, so their questions were well referenced and well cited, and then our response is we have to give an answer to the question, and then we should make the necessary cites and to the Practice Act and the rules as to our response. And then what I would like for us to do, other than giving a yes, yes, no answer, is to turn this over at the end and make sure that our executive director and our attorney will draft a response for us at our next board meeting to reference all of these issues. When we're making declaratory statements, we should prepare ourselves in answering the declaratory statements that they're going to be challenged, okay? And so we ask that we respond to this in a fashion that would be preparation for our challenge. If one so presents itself.
Do you want to read it onto the?
I kind of feel like we probably should.
Can you go get it off the copy? Thank you. Since everyone has a copy, I'm just printing one copy for Ode to read. For those who are on Zoom, does anyone else want a copy? A hard copy?
Of the response or the question?
Of the question that we're answering and Elise raised her hand. Does anyone else?
I'll take one. I had an issue printing out.
I'll share it with you. Mhm.
Do you want it up on the screen?
I think some of the same statutes that you're citing are here.
Okay.
All that commentary as the.
Wonderful. Thank you so much, Lee. I have to, remember them all.
I can read from the computer instead of waiting. Sure. All right. So May 28th, 2024, to the members of the Louisiana Physical Therapy Board regarding request for clarification on imaging referral by physical therapists. Dear esteemed board members, physical therapists have established a primary care role. With this additional responsibility coupled with an implicit or explicit duty to refer to our medical colleagues, the issue of physical therapist musculoskeletal radiological referral / ordering has emerged as a key issue. In a nation beset by critical and acute healthcare workforce shortfalls, exploring the physical therapist's role in expediting rural and urban musculoskeletal care to ensure health equity and public safety is timely and pertinent. Our national governing body, the American Physical Therapy Association, APTA, has produced multiple documents, including the Guide to Professional Conduct, the Guide to Professional Physical Therapist Practice, the Normative Model of Physical Therapist Professional Education, and the APTA House of Delegates Policy, which contains specific language directing physical therapists to refer to another healthcare professional if required services for evaluation or treatment or beyond the scope of the physical therapist. Specifically, the Code of Ethics, Principle 3C states, physical therapists shall make judgments within their scope of practice and level of expertise and shall communicate with, collaborate with, or refer to peers or other healthcare professionals when necessary. Likewise, the normative model of physical therapist professional education includes a specific requirement to determine the need for referral to other healthcare providers. The language used by our national governing body clearly delineates a duty to act rather than an option to do so. Given that the Federation of State Boards of Physical Therapy, the FSBPT's Model Practice Act of Physical Therapy, 7th edition, states the practice of physical therapy means determining a diagnosis and plan of treatment and referring patients or clients to other healthcare providers and facilities for service and testing to inform the physical therapist plan of care. 2, the American Physical Therapy Association, APTA. APTA recognizes imaging as being within the scope of practice of a licensed physical therapist. The APTA's official role is explained in the House of Delegates position statement, HOD POC 6-12-10-09 concerning diagnosis by physical therapists, which states, when indicated, physical therapists order appropriate tests, including but not limited to imaging and other studies that are performed and interpreted by other healthcare professions. Physical therapists may also perform or interpret selected imaging or other studies. Number 3, U.S. Department of Defense, U.S. Public Health Service, and the Department of Veterans Affairs. Imaging referrals by physical therapists is practiced in the federal systems, military branches. Predominantly, the Department of Defense has designated physical therapists as neuromusculoskeletal experts, in parentheses, NMSE. Given that the Louisiana Physical Therapy Board statutes and regulations do not explicitly address the issues of imaging referral by physical therapists, something that FSBPT and the APTA and the DOD all consider to be within the scope of physical therapy practice, we're writing to formally request the board's clarification. Relevant to our request to the board is the duty to refer clause found in section 303C, which states a PT shall exercise sound professional judgment based upon his knowledge, skill, education, training, and experience, and shall perform only those procedures for which he is competent. If during evaluation, reassessment, or screening, the physical therapist finds that treatment which is outside the scope of his knowledge, experience, or expertise is needed, the physical therapist shall notify the patient or the client and provide a referral to an appropriate healthcare provider. Furthermore, in section 2418B2, B states, if after 30 calendar days of implementing physical therapy treatment pursuant to this paragraph, the patient shall have not made measurable or functional improvement, the physical therapist shall refer the patient to the physical therapist shall refer the patient to an appropriate healthcare provider. The provider shall take appropriate the board shall take appropriate disciplinary action against any physical therapist who fails to refer a patient pursuant to this paragraph. In addition, section 345, unprofessional conduct B1D states, the board shall deem a violation any change of conduct, any charge of conduct which fails to conform to the Practice Act and board rules to carry out the provisions of the act, and shall take appropriate action where violations are found. The rules of this chapter complement the board's authority to deny, suspend, revoke, or take such action against a licensee or compact privilege holder as it deems appropriate, as used in revised section 37:2420A7 of the Practice Act. And in these rules, the term unprofessional conduct does not require actual injury to a patient and includes, but not limited to, the following: 1, departure from failure to conform; 2, or failure to perform on a continuing basis to the minimal standards of acceptable and prevailing physical therapy practice as defined in Rule 123, or of the commission of, or any act contrary to honesty, justice, good moral, patient safety, or the best interest of the patient, whether committed in the course of the licensee's practice or otherwise, regardless of whether an actual injury to a patient results therefrom, including but not limited to, D, failure to inform and refer the patient or client to an appropriate practitioner when the licensee becomes aware of the findings and or the need for treatment which is outside of the scope of the PT's competence. In short, we would like the board's response to the following questions. Number 1, when a physical therapist has reasonable cause to believe that symptoms or conditions are present requiring services beyond their practice scope, does the physical therapist have a duty to refer the patient in the most timely fashion to an appropriate healthcare provider practitioner to assist in managing the case when warranted? Question number 2, in reference to the first query and the statute cited above, does the board consider a board-certified radiologist to be a qualified professional or appropriate healthcare provider? Question number 3, does the statute cited above or any other part of the Louisiana Physical Therapy Board explicitly prohibit physical therapists from referring patients directly to a radiologist for appropriate diagnostic imaging studies? Regarding the third question, and specifically regarding our Practice Act's language on use of Roentgen rays and radium isotopes and ionizing radiation for diagnosis and therapeutic purposes, we respectfully ask the board to consider as part of its clarification that referral to a radiologist to an outside imaging center that utilizes ionizing radiation does not constitute use of radiation by the physical therapist within his or her practice, and that the Roentgen ray clause does not prohibit physical therapists from referring elsewhere for imaging. Of note, as a precedent, Colorado's Practice Act contains similar language, and this licensing board made a similar determination without requiring any changes to the Practice Act. We appreciate the board's time and attention to this matter. Sincerely and respectfully, Carl Kleinpeter, PT, APTA Louisiana President, Christina Fauché, PT, APTA Louisiana Governmental Affairs Chairs. All right, so we have 3 questions in front of us. And those are on the board. All right. First question. When a physical therapist has reasonable cause to believe that symptoms or conditions are present requiring services beyond their scope of practice, does the therapist have a duty to refer the patient in the most timely fashion to an appropriate healthcare provider or practitioner to assist in managing the case when warranted. That's the question on the table for discussion. We're now open for discussion.
You want to show, yes, you want to show the statutes on your slides?
They're the same ones that he just
Oh.
mentioned.
Yeah, I mean, I have a few other ones I think we should consider. 2418A indicates a physical therapist or physical therapy assistant licensed in Louisiana is authorized to practice physical therapy as defined in this chapter. A physical therapist is responsible for managing all aspects of the physical therapy plan of care. And then in our administrative codes, 303B, it's also stated that a physical therapist is responsible for managing all aspects of the physical therapy plan of care. And I interpret that as including referral, to qualified healthcare providers when as deemed, that the condition is beyond the scope of physical therapy services.
I agree. And I wanna just kind of highlight that word responsible, that's you being responsible in your profession. Like in my profession, I'm a mandated reporter. If I know about something that needs to go on somewhere else, I have to say it. I mean, I'm not the expert, but I think it's just the PT's responsibility.
Okay. Then there's one other statute, I think it is that we should consider. It's under the Administrative Code 369A. It says physical therapists and physical therapy assistants owe a fiduciary duty to patients to exercise their professional judgment in the best interests of their patients in providing, furnishing, recommending, or referring for healthcare items and services without regard to personal financial recompense. Say that correctly. The purpose of these rules and the laws they implement is to prevent payments to other healthcare providers as a financial incentive for referral for a patient to the healthcare provider for diagnostic or therapeutic services. But we have a fiduciary responsibility to do what's in the best interest, of our patients, including referring patients for healthcare items and services as dictated by statute.
Yeah.
Or the administrative code, correct me if I'm wrong, is the administrative code statute, or is that rules and regulations? Yeah, so as in rules, we have a fiduciary responsibility to refer patients for healthcare services, and items.
All right, so not only in our discussion will we come to, these are pretty simple yes and no questions, all right? We want to be sure that when we give our answer, that our answer then has a legal counsel and executive director go through the Practice Act and the rules and regs and cite our responses.
Just like we
Okay,
did last time.
all right, great. So can I hear any other discussion? So far, the answer to the question is yes,
We have,
from the members here.
we have a duty to refer.
Yes, okay. Any further input from the board members on this question? Any input from the public on this question? Any comment?
Hi, can you hear me?
Yes.
Yes,
Okay,
we will.
hi. Christina Fauché, PTA Louisiana Governmental Affairs Chair. I just want to thank the board for your time and consideration for this. This is something that that our members have been asking for clarification from. So this is very important to us. So thank you.
Good, okay, so I think the answer to the first question is a yes. Do I hear any nays? All right, so unanimous yes from the board.
Yes.
Then turn this over to attorney and staff. All right, question number 2. In reference to the first query and the statute cited above, does the board consider a board certified radiologist to be a qualified professional or appropriate healthcare provider?
Yes.
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 Yes, without question. Any further discussion? Any discussion or input from the public on this? Any hands raised out there? Seeing no hand raised, the answer to that question is a yes. And again, we'll also refer this to legal and staff for preparation.
I have some statutes that I can share with you.
Yes, and I've done the same thing too, so we all have probably. Question number 3, does the statute cited above or any other part of the Louisiana Physical Therapy Board explicitly prohibit physical therapists from referring patients directly to a radiologist for appropriate diagnostic imaging?
No.
We're hearing no's across the board.
What's your, can you list your statutes? I like to,
For the second question,
well, they probably
For the third
are
question.
similar. They probably are similar, huh?
similar, but there's another, in reference to this, you know, I found some challenges that we need to consider. You know, the first challenge that, you know, that I found relates to the language that's in our statute, that talks about physical therapy does not include the use of Roentgen rays and radium isotopes, ionizing radiation for diagnostic and therapeutic purposes. This is 24B. And this language is also in many other state practice acts, you know, where this question is being asked. And then I think it comes down to the definition of use. You know, so we have to consider the definition of use. In this statute, use is, in my interpretation of the statute, it's the practice of employing something or an employment or application of something, a method of manner or employing or applying something, the privilege or benefit of using something, or the ability or power to use something. And so that comes from Merriam-Webster, is when I looked up the definition of use as I understand it in the statute. So I think this poses a challenge, you know, that we'll have to address and, you know, and overcome in the event that this was challenged, you know, by, you know, other entities, you know, and needed to be discussed with the Attorney General if it came to that. I think that statute is a barrier for us. And then further, in terms of referring directly to a radiologist, there is the Code of Federal Regulations that we have to take into consideration. The Code of Federal Regulations, you know, indicates that except otherwise stated, provided in the section, all diagnostic X-ray tests, diagnostic laboratory tests, and other diagnostic tests must be ordered by the physician who is treating the beneficiary, and that is the physician who furnishes a consultation and treats the beneficiary for a specific medical condition, and who uses the results in the management of the beneficiary's specific medical condition. Tests not ordered by the physician who's treating the beneficiary are not reasonable and necessary. And then the Code of Federal Regulations further states that all procedures that are performed at independent diagnostic treatment facilities must be specifically ordered in writing by the physician who is treating the beneficiary. That is, the physician who is furnishing a consultation or treating a beneficiary for a specific medical problem, and who uses the results in the management of the beneficiary's specific medical problem. The order must specify the diagnosis or other basis for the testing. The supervising physician of the independent diagnostic treatment facility may not order tests to be performed by the independent diagnostic treatment facility unless the independent diagnostic treatment facility's supervising physician is in fact the beneficiary's treating physician.
Read that last sentence again.
The order must specify the supervising physician for the independent diagnostic treatment facilities, the imaging facilities. They're called independent by federal regulations. They're called independent diagnostic treatment facilities. The supervising physician for the IDTF may not order tests to be performed by the IDTF unless the IDTF supervising physician is in fact the beneficiary's treating physician. That is, the physician in question had a relationship with the beneficiary prior to the performance of the testing and is treating the beneficiary for a specific medical problem. The IDTF may not add any procedures based on internal protocols without a written order from the treating physician. So by the Code of Federal Regulations, if these diagnostic imaging facilities are in fact participating in the Medicare program, then they would fall under, correct me if I'm wrong, but they would fall under the Code of Federal Regulations.
Say that last part again.
If these independent diagnostic treatment facilities are participating in the Medicare program, which is a federal program, then they would fall under the provisions of the Code of Federal Regulations.
Yeah.
So in so much as these diagnostic treating facilities have radiologists on staff who are in fact not the treating physicians for these patients, then we cannot order or refer directly to them.
Unless, so we can refer.
Yes.
They might not could accept. I can throw the pass. They might not be able to catch it.
Is that, but would that be doing the patient a service?
Now, I would then say, there's always an unless that, so the question here is, can we refer to a radiologist? So question number two, are they an appropriate professional? Yeah, they are. Okay, we can't, nobody died and left us folk. We can't say they're not an appropriate healthcare professional. If that radiologist so chooses to accept the referral as a referral, then he indeed may order the test. Because he's accepting a referral from us.
Only if he's a treating physician.
He may choose to become the treating physician by accepting a referral. So we can't prohibit that radiologist from becoming a treating physician. I don't think anything precludes him from doing so. It just says if you're not the treating physician, you can't sign orders to order things in here, and we can't be a mill where we're just gonna, our protocol says, now we're gonna do an MRI with contrast. Unless somebody that's treating the physician requires that, just the facilities protocol can't add requests. The guy who reads them shouldn't ask for requests unless he chooses to take on the role as the treating physician. I think in some cases, we're finding around the state that they're willing to do so. And in some cases, they may not be willing to do so. They may be prohibited from their contract with, with their imaging center.
I always appreciate looking at
Yeah,
federal regulations and insurance policies because it's a part of the picture, right? And those are contracts, and so it's a part of the picture. So I always appreciate that perspective. For me, I didn't go there with this particular question because the way that I was reading the question is different than the previous question that we had before. Is they laid out their question very clearly and what specifically they're asking. And so the third one, it's asking specifically, does our statute prohibit it? And so I feel really comfortable saying, no, our statute doesn't prohibit it. I'm not speaking on behalf of other arrangements or other entities or other organizations or other insurance contracts or that kind of thing. So I feel comfortable answering it specific to our Practice Act.
Because in the past, we've taken the position that we are not the enforcer of reimbursement guidelines. Okay, people do fraud, that's a different story, okay? But our job is not to be Blue Cross's police, we're not Medicare's police, we're not the enforcer of their guidelines. That's their problem. Okay, and we can't solve their problem, okay? And it may be, so if your question was the federal guidelines apply to federal payment, if somebody wants to pay cash for the MRI, does that prohibit? See, that's a reimbursement regulation and not a licensure regulation.
Now, I will say if some of those other things that are not in our Practice Act are federal laws or rules, right? So like there are like HIPAA, anti-kickback, like False Claims Act, like all of those things that are laws do apply, right? Because we, in our Practice Act, state that people are bound, that our licensees are bound by the applicable laws, laws, including the Practice Act, which is a law that regulates their license. And so kind of just to say it a slightly different way than you did. So it is not our job to enforce contractual relationships between other parties. We enforce the laws and regulations of the Practice Act and the applicable laws to their practice. Is I think a cleaner way to say that.
I think in crafting our response,
Yeah.
My concern was, okay, there are statutes, that govern, the practice of these independent diagnostic treatment facilities that our licensees may not be aware of.
For sure.
Okay, so, number one, we're discussing question number 2, as to whether a radiologist is a qualified person for us to.
Three.
We already agreed that radiologists are
we're talking
qualified
three.
healthcare professionals.
Okay, all right, so the question here then says, does it prohibit physical therapists from referring a patient to a radiologist for diagnostic imaging?
You gotta stick to the question.
Yes,
No.
gotta answer the question.
For other things.
That's correct.
So in your research, Lee, did you see any like federal law, not like Medicare contract regulation, kind of thing, but any federal law that gave you any pause?
No, no,
Okay.
because the the code of federal regulations relates to, payment.
Right.
Under the Medicare program.
Right,
Right, and so the idea
through
is,
that contract.
through those
Yeah.
contracts.
Yeah.
So, when I was reviewing that, I said, okay, these independent diagnostic treatment facilities, what are the guidelines? What guidelines do they have to follow?
Right,
Because if we're saying that radiologists who work in these facilities are qualified healthcare providers, and physical therapists have a duty to refer to a qualified healthcare provider when the determination is made that the patient's condition is outside of the scope of our practice, then when I took into consideration who are we referring to, and then what information do the licensees have to have about the statutes and principles that govern the practice of these facilities. Because it would be for us to have ignorance of those
yes,
regulations
yes,
and make referrals for our patients to
Yeah.
those facilities, and those facilities not able to receive,
mhm,
and be able to accept that patient referral, that is not doing a service to the patient.
mhm. Yeah, I think it's a good point, right? So, but,
Yeah.
so what I'm gonna say is it gets back to like the previous question that we had before, is it's like, like, here's another little pearl of knowledge that would be nice for you to know, like, we're answering the question, but like, yes, the radiologist is a qualified person, and no, there's nothing that excludes it, but like, could a patient actually get there faster by referring to their primary care, like the physician who referred, you know what I mean? Like, that can be a whole other conversation, which I think is what your point lends to. And maybe all these other like little helpful pearls are things that we can provide educational materials, just generally speaking in the future, you know what I mean? Like, here's just helpful
Yeah.
pieces of information,
And
but
some of
it's
this,
different than
some of
the
this
answer.
discussion is gonna be very germane to the next question.
Right.
Because now we have a question from an imaging
Oh,
center,
right, yeah,
from a facility
right,
that is being sent referrals from a physical therapist, and that
Right.
person's asking, can we accept these?
uh-huh,
Okay,
yeah,
so this may be way more germane to the second question.
yeah, great.
So to this question by the APTA Louisiana, number 3, does the statute cited above or any part thereof of the Louisiana Physical Therapy Board explicitly prohibit a physical therapist from referring patients directly to a radiologist for appropriate diagnostic imaging?
No.
And so there's nothing in our Practice Act that prohibits us from doing so.
Correct.
Okay? All right, so that answer is no. And then again, for this answer, and I would ask that when we answer these questions, because I think somewhere else it was mentioned wellness, that we respond to all practice settings. And just
Wait, what?
that we make sure in some of their footnotes and citations, they discuss wellness setting. So we need to answer this question too. Is it just in the clinic when you see them clinically? Or if you come upon someone in the wellness setting and you're doing your evaluation and your screening and you think, oh, I'm not sure they qualify for wellness, something's going on here, I need some more information. Well, just be sure that our response is broad enough, that we don't limit our response to a practice setting.
Well, but would that then, the statute, says if during the evaluation, reassessment of screening, so screening is included in that.
That's
Okay.
my point, yes.
I
Okay,
was concerned that was gonna be an
yes,
answer.
yes, okay. All right. Any other discussions on this question? Any comments from the public? Okay, hearing none. Is it the pleasure of the group that we just refer this to legal and executive director? Would you like a motion?
Let them handle it.
Okay, all right, so they have heard our responses and our responses are yes, yes, no. We'd like something a little bit more intelligent than yes, yes, no, with references to the Practice Act. Because in the past, these questions have arisen and some of the jurisdictions answered the question, yes, yes, no. And didn't give any reasoning, right? We'd like to give reasons, and as the questions are becoming more mature across the country and boards are being asked these questions across the country, then the responses are getting more sophisticated, and I believe that we should try to, as always, give the best answer that we can. All right. Next
So
question.
to be consistent with the
Okay.
last meeting, there will be a motion to, draft a response, at the next, and put it on unfinished business, but on the slide deck, it's after the next question, since they're both related to the same topic.
So we'll make the motions then.
That's where it is on the slide deck. Is that okay with you all? Okay. We'll
And
have
we
it.
just decided that we would just make an assignment, not make a motion, because, you know, we've talked about it all around, so.
Right,
we may
at
not
the
have-
last board meeting, y'all moved to authorize us to work on it and bring it to
Yeah.
unfinished, so we'll just be
Great.
consistent.
Okay,
Okay.
all right.
Did they want to pause to get lunch and bring it back in here, or how do you do that?
I think we only have one more.
Well,
thing to
yeah.
do.
Just
Do y'all want to? Yeah. let's
No,
do
we're
it.
gonna keep moving, yes. All right, next question. We received an inquiry from a licensee. Now, let's see. All right. So we've received question from the Imaging Center. Can I have the question from the Imaging Center? Can I have that letter?
Sorry, I can print it for you if you need. Do you need it? Do you need it?
So I can read it for the record?
Yeah.
All right. All right. The question is, O'Day, it was good to speak with you a few minutes ago. I have attached the latest document as a reference. We discussed my two questions. Just lost yours. Yeah. Where I find it? Put it in front of me, it's not here.
Okay.
All right. Here are the questions. Number one, are there any prohibitions for a physical therapist, parentheses, one with a doctorate or one without, from referring, parentheses, writing the physical therapy order for medial, but it should be medical imaging, I presume. These are the subsections to the questions. Number one, can PTs refer patients for medical imaging that uses radiation? Number two, can PTs refer patients for medical imaging that does not use radiation, such as ultrasound and MRI? Number three, can PTs refer patients to medical imaging that uses contrast or isotopes along with the imaging? Question number two, please refer to the bottom of the Practice Act in reference to the scope of practice mandates for the rad techs, radiology technologists, to apply radiation to human beings. One, that this becomes a sticking point that will be reached out reach out to the Louisiana Board of Radiology Technicians. I would like your opinion from the State Association on this paragraph. So we can't speak on the State Association. I do believe he's asking for the state board's response here. Number three, congratulations on being the chairman. All right, so we all know that in number 2.1, that rad techs have a list of people in their Practice Act who they can accept referrals from. The list is inclusive. We are excluded from that list. It's doctors, surgeons, dentists, podiatrists. We've all seen that list before, chiropractors. Okay, we're not on that list. That, I think, has been the problem all along, is that if PTs have thought that they could make the referral and have been making referrals to facilities, then they're being stopped at the door, say, well, you know, our rad tech can't take an x-ray from you because you're not on their list. So somebody needs to work with them to change their list if indeed they want to accept referrals. So now this is, can we refer? Yes, we can. Can they accept them? Maybe they can't. That goes maybe now to some of the discussions that you were having
Yeah,
earlier.
I think we need to clarify the difference between referring and writing a physical order. I think this question should be, what they're asking is, can PTs refer? If their interpretation of referral is writing the physical order, that isn't the same interpretation that I have. Because our duty is to refer. So if there is if there is a condition that's beyond the scope of physical therapy practice, and we're going to refer, say, to a cardiologist, we're not writing an order for a cardiologist to tell the cardiologist what the cardiologist needs to do. We are referring them for their consultation and for their medical expertise and to take on the care of that patient. We're not writing an order. So the difference between refer and order is germane to this conversation. So we cannot order medical imaging that uses radiation, is part because of our own Practice Act. Because it says under 2407B, physical therapy does not include the use of X-rays, radium isotopes, and ionizing radiation for diagnostic or therapeutic purposes. So my interpretation of that is that no, we cannot refer patients for medical imaging that uses radiation if you're saying order, if referring and order are synonymous terms, then we cannot order imaging that uses radiation. The fact that the RTs can't accept our order is a different issue. And that's for them to solve, you know, but the ideas are, I think, my interpretation of the statute is that if we're writing the order, if the order is written for either diagnostic or therapeutic purposes. In our Practice Act doesn't allow us to do that. We can refer, as we discussed previously, you can refer them to a radiologist, but you're not writing the order to tell the radiologist what to do. You're asking the radiologist for their expertise, for their counsel, to take on the care of this patient, you know, and then make recommendations for the treatment of this patient. That would be an appropriate referral. That would be the implied intent of the referral. So I disagree with the definition of referral and making it synonymous with writing the order.
You know, so I'm gonna throw myself into the mix instead of sitting at the chair and coordinating the discussion. I would professionally like to disagree with that, okay? The Practice Act says that we cannot use. Doesn't say you can't refer, doesn't say you can't order, those words aren't there. Okay, we have to read the words. It says you cannot use. Then you go back to legislative intent. And the legislative intent back in the 70s was that physical therapists won't be able to have an x-ray unit in their office and perform x-rays on their patients. That was the legislative intent. Okay? And at the time we needed a referral or a prescription. You know, at the time referral wasn't invented, we needed a prescription. The doctors told you what to do. They told you how fast to move the ultrasound head. They told you what the wattage on the ultrasound was. We're not in those days, okay? And so we have to answer the question based upon what his question is. Number one, we're answering the question. And number two, we have to look at the legislative intent of the word use, Roentgen rays, ionizing radioisotopes for diagnostic or treatment purposes. We're not using them. I don't believe I'm hearing anyone ask yet today, can we use an x-ray in our office, in our practice, in our nursing home, on the field?
Well, I guess, as I said before, I think it looks at the definition of use. You know, I mean, what is your definition of use and how are you defining that? You know, I just looked up the Merriam-Webster dictionary and looked at their definition of use. You know, and as I said, in the terms, the way it's written in the statute, my interpretation of that is that the act or practice of employing something, the method or manner of employing something or applying something, the privilege or benefit of using something, the ability or power to use something. So in terms of the definition of use in the statute, I believe it implies to the privilege or benefit of using something, or it applies to the ability or power to use something. I don't interpret that as I'm actually the one pushing the button on the X-ray machine to take the image, because I haven't been trained to do that.
Okay, so I'm confused as what your point is.
I just disagree with the definition of use, my point is that referring and writing the order are completely different, in my opinion. And the way the question is framed, I think needs clarification. Because the interpretation from this imaging center is they're not making any differentiation between referring and writing the order. So
I'll through my experience from dealing with physicians in this particular kind of referring physical order thing. And maybe the person, what's his name, Michael, who wrote this wasn't thinking about it in a similar way, right? People throw out these words, prescriptions, referrals, orders, et cetera, plan of cares, whatever. So I can tell you that I have really great working relationships with lots of different physicians, other healthcare providers, and we refer to each other because we work as a team, you know, in a lot of ways. And most of the time I'll call up or text and say, hey, I have a patient that I really need you to see. And I'll say, I'm specifically seeing this, that like, I really want you to use your brain because it's not my brain to look at that. And they will say to me, they will actually ask me to physically put it on a script pad and write down what I'm asking for them to do. So I'm asked to, so instead of writing like a note, that's just their language. They use those forms, like send it over to me so it goes through our system the way that it needs to. And even though I write some of my thoughts, you know, down there, things that I'm like hoping that maybe they can look at because something smells kind of funny, right? And I can't decide if that funny is real or not, right? I need them to do that. But for whatever reason, people who are in that world, they need that physical something. And so I guess I never thought about it before, that it would be like me ordering something. It's just a communication mechanism. And so I don't know Michael's world, if he's just in this imaging world and all the communication happens in these like physical
I can't speak to that.
forms. I don't, right?
Yeah.
And so I'm not sure, it lends itself back to before. I'm not sure the interpretation of the physical order, thinking about it the way that maybe you do versus he does versus. So it's kind of a unknown. And I just never thought about it the way that you're presenting it, because it's something that I do a lot of times.
Yeah,
Because the physician asks me to. And if I didn't do that, then the patient wouldn't get to the physician, because that's how that physician's world works. And so I'm happy to comply to make sure that patient gets to that physician, and then that referral happens. So.
Yeah, and even then, you know, the average physician, are they ordering their X-ray? Or are they requesting an X-ray? Do they say, you know, I need an AP, a lateral, and no, they say X-ray shoulder, possible rule out fracture.
Yeah.
Okay?
Yeah.
So is that an order? We're not telling people what to do. We're making a referral, we're making a request, because I don't know, I'm pretty stubborn. I don't do anything anybody orders me to do. If they ask me, I say I might, okay? So, you know, again, the word ordering, writing it down, a piece of paper, a referral, you know, they're all gonna want some history. They're all gonna want some information. It's all gonna be written down. So I think, you know, now, he understands that there's a roadblock there, that in his world, his rad techs really can't press that button upon our request, because we're not a person that's requesting.
Whether it's verbal, written down,
Yeah.
whatever.
But that's their problem.
We're not considered licensed practitioners underneath their statute.
Right.
That's correct, all right? It's that, You couldn't come to me and say, you know, I didn't refer this patient out because they can't take my referral, and you continue to treat that metastatic fracture. Well, you know,
Right?
it doesn't matter if they can take it or not, you gotta get it out of your office.
Yeah.
Okay, and then somebody's gotta get a workaround. Either there's a doctor on staff that'll write it, you may have to refer it to their patient. You know, is it prohibited?
Mhm. Right. And I would say I think that's a really good example that you just used, because like same thing. So like if we see a patient who we're trained to recognize if something looks fishy,
Yeah.
right? That's the point of what we are as professionals, cancer, like big red flag stuff, even yellow flag stuff. And so I can tell you that I've had patients, direct access patients come in and I've referred them straight to an oncologist.
Yeah.
Right? As opposed to back to their primary care, back through that system and be really glad that it did, kind of thing. And so I guess that is a very similar
The
example.
intent of your referral at that point is you're going to, that oncologist will then go ahead and evaluate the patient, use their clinical expertise.
Right,
To treat the patient.
right,
And develop a plan of care to address that patient's need.
Right.
And that may include diagnostic imaging.
Right.
As part of their plan of care.
right,
You're not writing an order, but telling the oncologist what to do.
right. But what I'm saying is oftentimes like even that situation, they'll say, write something on paper. So like I can write on a piece of paper, like I never thought about it as an order, I'll put like, please evaluate and treat this patient.
Right.
And then I may submit other information. I'll get on the phone with them and be like, hey, here's what's going
The
on.
question that I would have is that what the referral to the imaging center is gonna say? Is the referral to the imaging center gonna say evaluate and treat?
I don't know the answer to that question. I just see it as a similar
Right,
type
I
of,
see it different.
Okay.
I see the order is, like you said, I need you to do, plain radiographs to rule out a fracture, right? So that's not, I need you to evaluate this patient and make recommendations. I need you to do plain radiographs to rule out a fracture. I'm not gonna tell you which radiographs to do. I'm not gonna tell you, which views to do. I need you to do plain radiographs to rule out a fracture. That's not the same as evaluate and treat, in my mind. That's not the same. So when I know in the health system, when the order goes down to radiology, the radiologists never see the patient. They don't consult the patient, they don't evaluate the patient, they never lay hands on the patient. So you wouldn't send an order down to radiology and say evaluate and treat. I wouldn't refer somebody to radiology and say evaluate and treat.
But in that instance, they're already in the hospital. They've been admitted. So you're reporting back to some system, to some medical record, to some particular instance. And now we're getting into the contractual relationship of that radiologist, okay? They would all love to just sit and read and not have to worry about making any treatment diagnoses, okay? And treatment interventions. They just say, yes, here's what I think it is. Somebody needs to do something about it. Okay, so that always has been the concern as an entry portal into the healthcare system is that was the fear from all the orthopedists that they put up there. You physical therapists are gonna miss cancer. Okay? There's not been a complaint filed yet that anybody's missed cancer. There's been no malpractice claims. Okay, so what this does is if we suspect something, we need to refer them out. So the question was, then what happens if they have cancer and you send the radiologist says, I suspect a tumor? It's gonna make yet another referral to the appropriate healthcare provider, which won't be us. It'll be to the oncologist based on the findings, okay? So, is there anything in our Practice Act that prohibits us from doing the things that this gentleman is asking?
I think Lee's getting caught up about the referral definition.
Yeah,
It looks
yeah,
like he's defining referral, so then it makes it hard to answer the rest of the
Believe,
questions, is
believe
what
you
I'm
say you
hearing
can
from you.
refer, we just don't have to be as specific on the order. Like, you might need to go see a radiologist, but not saying exactly what you need to go see a radiologist for. You're saying,
Yeah.
don't write it down on paper,
You're referring them for evaluate and treat. I mean,
Right.
as Katie said, so the idea would be, I've got a patient in my office, something looks suspicious, I'm gonna refer them to the radiologist for an evaluation.
Right.
And then.
You're not ordering them, hey, you need to x-ray that left.
But you're saying in real life, that would never actually happen
That doesn't happen in my
in
health
your
system.
hospital,
Right,
right?
right.
But, yeah,
So this gentleman.
I can't speak to what happens.
right,
In the rest of Louisiana.
Right.
But I would
Right.
never
Yeah.
refer someone to radiology
Without
with a
order.
Valentry.
Yeah.
Like that would not, because they're not going to evaluate the patient.
No,
They want, yeah,
And the
right.
rad tech's not interpreting,
Shoulder.
and not interpreting your orders. It has to
Well,
be
and the
come
rad tech
from,
cannot take
Right.
my order.
right, that's what I'm saying.
So the rad tech cannot, because I'm not a licensed
Right,
practitioner.
and they're referring to rad tech.
The rad
in
tech
his.
is, so in my health system, I have to pick up the phone and I have to call the primary care physician.
who's the referring
Who's
to
taking,
begin
who's
with?
taking care of, who's caring for this physician. And say, listen, I need you to do this for me. This is what I'm seeing. This is my concerns. Let's go ahead and then rule this out. And so then the referring physician then writes the order
Right.
to go ahead to radiology. The radiologist interprets the images. We get the reports back. And then, as you said, the interdisciplinary collaboration is very valuable, for the patients.
Yeah.
So I can't speak to what happens outside of, in the rest of Louisiana,
Yeah.
but I am hung up on the idea of saying referral and order are synonymous.
Mhm.
So
Yeah.
I'm stuck on
I'm
that.
hearing you with that.
Yeah,
Let's try and answer the questions.
yes.
And maybe as the answer is kind of drafted, we're gonna have to, it's one of those things that the referring physical order. And I don't know, you obviously talked to this person.
Yes.
Did he make it clear to you what his real intent of this question is?
Yeah, he's got a so this gentleman, I think he's the CEO of this, this imaging center, and they're, outpatient based. They're in New Orleans, in the Baton Rouge area, they're in the Alexandria area, and he said, I've gotten referrals from physical therapists in New Orleans and in Baton
Like,
Rouge.
and when he says referral, he means like he got a physical piece of paper? You think?
Uh,
You don't know? Okay, never
I
mind.
don't know.
Okay.
I didn't ask.
Okay.
Didn't ask him, didn't ask him any specific. I got two PTs, I have two patients coming from two different PTs, one in New Orleans, one in Baton Rouge. They want to send their patients to me for imaging. Can PTs do that?
I got you.
That's the question.
Okay.
Now, I might have misguided him to say, be careful how you ask the question. We can only answer the question that you're asking,
Mhm.
okay? So here's the questions that he sent to us.
Yeah, okay. So can we go to like 1A and let's just say if you send a patient, right, for imaging. And think about it globally, and then maybe we can answer more specifics. I don't know. So
I think if we remove the order and just say refer, then I think we're back to our previous conversation.
right, right.
Yes.
We're back to our previous conversation. If we remove
Right.
if we remove the clause in there that says writing the physical order, and then we just go back to referring.
Using that word, because that word is referenced in the Practice Act
Right.
as well too.
Yeah.
We
Right,
have a duty to refer.
right.
Yes.
So I think if we have a duty to refer, and I think that, if we are clear in our definition of referral.
Yeah.
I don't think we're gonna have a problem.
And in our previous question, the question was, is a medical doctor who specializes as a radiologist, is he an appropriate healthcare provider?
Yes.
The answer to the question was yes.
Yes.
Okay. He or she may limit their practice to diagnostic reading only and not choose to take on a patient and be involved in their healthcare. Okay? Then you'd have to find another radiologist. We fought all our lives to have direct access and treat without a referral. And most of the intricate, high-level specialists, they all work by referral.
Mhm.
Okay, because they want you to do the work up first. They just want to do their magic. They don't want to treat the patient and all the other histories. They just want to do their little thing. We make reference to the cardiologist. So now it's the same thing with the radiologist. They would prefer just to read imaging and not talk to patients, okay? Surgeons, prefer to do surgery and not talk to patients. Their patients are asleep when they're working, okay? And so,
We're just making global statements.
yes, we hope that, we hope.
So
they're
let's
asleep.
look at A. So
Yeah.
can PTs refer patients for medical imaging that uses radiation? I think we've already answered that question in the previous,
Yes.
Yes.
right? Yes. Can PTs refer patients for medical imaging that does not use radiation, such as ultrasound and MRI?
Yes.
Yes, right? I mean, yes, okay. I mean, same thing, right? Same question.
They're making a referral.
Yeah, can PTs refer patients for medical imaging that uses contrast or isotopes along with the imaging?
Sure.
No problem.
Yes.
I'm saying yes to that as well too. So I think that answers his
Should we-
questions.
Yes, I think it may answer Lee's question, okay? Can we use, because here we just said we can refer for things that require radiation. And our Practice Act says you can't use radiation.
Well, yeah, so my contention would be unless we change the Practice Act, we would not be able to write a physical order. That would be my interpretation of the statute and what would be necessary in order for us to be able to have, the ability to write the physical order and make recommendations, including but not limited to the views, the type of view you want, and so forth. I think we need to get that statute changed because I think we're in a losing position if we are parsing the definition of views. Okay, if we're going to, mince words with what is the definition of views, I think that's a losing scenario.
Yeah.
So I think if we agree that refer is not writing an order, refer is a valid treat. I need your guidance, I need your counsel, I need your expertise. If that's our definition of refer, I don't have any problem with it. But I think we're gonna be stuck, we're gonna be challenged if we are saying that we can order and we can make recommendations for specific imaging modalities, as opposed to referring to a licensed healthcare provider. And a radiologist is a licensed healthcare provider in the state of Louisiana, and asking them for their guidance and asking them for their assistance in the management of this case. So eval and treat this patient. And then, as you said, if there are radiologists in the state of Louisiana who in fact want to change their practice and actually start evaluating patients and actually start participating in the care of that patient in the development of their treatment plan, then I think it would be great for us to know who those radiologists are. So that we can provide guidance, to our licensees, with who is willing to do this.
And from what I'm hearing in the field, in the world, there are radiologists that are willing to do that.
Great.
Okay?
Okay.
So whether they are or they aren't, we only have one job, and that's to interpret the Practice Act as it's written with the legislative intent.
Can I ask you a question
Yes,
about
ma'am,
that?
please.
Since you seem to know a lot about the legislative history, how the practice was previously restricted, and always had to have a referral, now they don't. And I don't know all of the history behind that, but I do know that when I look at the Practice Act, every reference to refer is to refer them to a provider. It's not refer for additional testing, additional treatment, it's refer to a provider. Provider always follows it. And so I'm wondering if there's a specific legislative intent there, where they're saying, we'll give you a longer leash, physical therapist, you can treat without a prescription or referral, but at a certain point, when it's outside your scope of expertise or they don't improve in accordance with the Practice Act, you have a duty to refer them to an appropriate provider. Is that meant to be limiting? Because it may be, in which case we can't get into medical imaging.
So if we then, so again, as our attorney writing this, I would suggest that you, we review, not you review, I'm not ordering you what to do, or writing it on a paper for you.
You can.
I can.
That one can.
Yeah, the Model Practice Act by the Federation and I think the clinical guidelines, they also, when we have in our definition, objective tests. The belief for objective test could be an image. That's an objective test, okay? So we have a requirement to send our patients. We have that privilege because we just, we were prepared to defend this in the legislature, okay? And so to make it really clear in the legislature, what we're attempting to do was to place our name on the list. It could be as simple as having the rad text add our name to the list. It could be as simple as a rad text saying any licensed healthcare provider. Okay, and then all of this goes away. because it is in the training today. Now, if you go to CAPTI and you look at our educational process, and Phil, help me here, is that we are trained to do differential diagnosis. We are trained to determine, is the X-ray what's the gold standard here? Sprained ankle. Gold standard might not be rushed to an image. It might be an X-ray, okay? Our physical therapists have that in their education today, okay? Was that in their education in 1969? Probably not, okay? And this is all left over from the battle between the docs and the chiropractors. And when chiropractors got licensed, every state closed the door behind them and said nobody else was going to use X-rays, because they didn't want chiropractors to have X-rays in their offices. That was the legislative intent. And again, I don't think that in the late 60s and early 70s that the legislature could imagine that there are other diagnostic images that don't have X-rays. There's MRIs, there's all sorts of things now, okay? And so what they did not want us to do was to use X-ray in our office. Okay, there are many, many spots in our practice act that says objective tests, measurements, facilities, refer out, get information, come to diagnosis, draw a conclusion. Now, how it works in a facility, governed by, again, now it's governed by Joint Commission, it's governed by Medicare, it's governed by somebody else. The admitting physician is the only one that can write those orders. Oops, he makes a consultation. Then the consultating person can come in and write something in the plan of care, all right? It may not be able to be allowed in the hospital, but we're not regulating hospitals. We're regulating physical therapists and all practices that need to be informed and find the appropriate information for their patients. I interpret use as to have an X-ray machine in my office and me telling the rad tech to do it. I don't think for a second that the word use X-rays means we can't send them out for an X-ray. Or we can't obtain an X-ray by hook or crook, whether you have to have 3 referrals to the family practitioner, that's then gonna send them to the imaging center, or you send them to the imaging center. That's somebody else's business. We need to get these patients out of our office in the most expedient fashion to get the knowledge that we can to treat them. Okay, so. And we'll go to the questions from the imaging center again. Because here, we said it's okay to send them. And now, because he wants us to write it on a piece of paper, we're all taken back. Let's not let that piece of paper drive our answer, even though he did kind of put that in there, because Katie, he's like you, everybody works off a piece of paper.
Yeah. Well, and I would say, just as a part of this conversation for future, just always looking at the current, but then like, there's always room for improvement with everything that we do. Times change. And so keeping up with everything. So if you look at the definition section in the Practice Act, the word referral is there, right? And so if you haven't read it today, it's not a comprehensive definition of referral, especially even the way that it's used in the Practice Act. I mean, they use the word referral to refer to other providers, but the way that it's defined
Yes,
in the Practice Act is a request for physical therapy evaluation or treatment,
right.
basically. So it is not,
That refers to us.
I know, but I'm just saying,
Right.
like, if you're gonna define the word referral, like you should also, and you use it in other senses,
Sure.
we could improve the Practice Act and, include a more robust definition of the word referral.
That's, yeah. Yes.
No, I know, yeah. So as we're looking at our next rules revision
Yeah.
committee, I'm saying this may be definitely something that is clearly lacking.
Sure, absolutely.
Yeah,
So when these rules were written, no one was looking at it as the referral leaving us and going to someplace else.
Exactly.
It was the one-way
Yeah.
street in.
Yeah.
Yeah. Now, there is, when we met with, our authors on the bill this year in the House, one of the authors was a chiropractor. And his point was, y'all are now entry portals into the healthcare system. Everybody that's an entry portal into the healthcare system needs to be able to refer for imaging. Because otherwise your hands are tied behind you and you're gonna find yourself and your patients in some precarious situations, okay? So he was willing to make a broad statement. All right, so I think part of the, now, that's gonna require legislation on somebody else's practice, because there's a little roadblock over there in the rad tech. And we've always known that,
Yeah.
okay?
So that's the last question. So we already talked about A, B, and C. So then 2A is, and he's saying, I would like your opinion. Again,
back to
he
the
says
question.
state association on this paragraph. So
Those are the questions.
It's
It says
2A.
2-1 up there, but it says this is a sticking point. We'll be reaching out to the Louisiana Board of Orchard.
So he's asking for the opinion, so I
I'm s-
don't
yeah.
really have an opinion other than it's what it says, right, as a board. So just as we're answering the questions personally, I mean, that is what it is,
It's outside of our scope. It's rad tech question.
right?
That's correct, so.
We should
So our
know.
opinion is if you want information about that, he should go
Yeah.
to. the
Yeah,
rad
no,
tech
our
people.
response has to be, there's nothing that prohibits us from doing it. We believe we can order things with radiation and not radiation, and, refer, request, okay? Request. But acknowledging that there is an issue with the Rad Tech Practice Act,
Yeah,
that,
and take it up with them.
yes.
But, and if the referral is for a valid treat, the rad tech's not gonna do that.
Mhm.
So if the if the intent of the referral is for the radiologist to do an evaluation and participate in the management of this patient, then the radiologist, who is on the list of licensed practitioners in the Radiology Technologist Practice Act,
Then it's a moot point.
it's a moot point.
Right.
So again, this is, I think, as a board, I think we need to give our licensees, clear guidance here. And the idea is that, you have a duty to refer. When you make the determination that the condition that the patient presents with is beyond the scope of services that you can provide. So you have a duty to refer. You can refer, okay? It would not be sound judgment to refer to someone who has no intention of seeing the patient. That would not be considered sound clinical judgment. So I would not make a referral to a radiologist unless I knew in advance the radiologist is going to evaluate and treat the patient. That would not be considered sound clinical judgment. So I need to know that if I have a relationship with you, and if you have a relationship with an oncologist, and you call the oncologist, you have an expectation of what's gonna happen, and that there'll be a patient and provider interaction, and that there'll be a relationship started, and then as we discussed before, there'll be a duty established. Okay, so that would be considered, that would be a reasonable and appropriate impression or expectation that you would have upon making that referral. Unless I knew in advance that I had a radiologist who was going to do an evaluation, and participate in care of this patient and establish a duty to this patient, it wouldn't be sound judgment for me to refer them to that radiologist.
Lee, their evaluation is an X-ray. They're not gonna touch you. So to me, that evaluation, that solves that problem. They're evaluating you. You're not asking for treatment, you're asking for evaluation.
So then it goes to the Code of Federal Regulations.
That's a Medicare question.
Right.
That's not,
But that's something that if they participate in Medicare,
right,
if
that's a different
if the
question.
radiologist participates in Medicare, then they are prohibited from just doing imaging.
Correct. That's,
They
that's on
actually-
them though.
Right.
It's on
Not
them,
us.
on them.
So I have no problem saying, referring and not saying you have to evaluate and touch them and go through a full clinical exam. That's not what they do. They evaluate them with X-ray.
Mhm.
So as long as we agree on that, then I agree with you on that situation. And I agree that using referral is the way to go, not order. We shouldn't put that, and that's not the question. The question is refer. To your point, I see, refer to a medical professional. Well, it doesn't have that word here. It says for medical imaging. You just don't have the word to a professional for medical imaging. We can still say, yeah, we can refer for medical imaging. It just doesn't say that
To
you have
who?
to go to a provider that does it. Well, I see that point too.
Yeah.
But the answer is yes, yes, yes.
So in constructing our response, should we write, yes, physical therapists can refer patients to a qualified healthcare provider for medical imaging
Yep.
that uses radiation. Physical therapists can refer patients to a qualified healthcare provider, for medical imaging that does not use radiation. And physical therapists can refer patients to a qualified healthcare provider for medical imaging that uses contrast or isotopes along with imaging.
Absolutely.
That should be the language.
Yeah.
Yes, correct. Correct. Because we have no jurisdiction on their side of the fence as to whether that person can take it or that person needs to have a patient-physician relationship. They need to determine what their patient-physician relationship is, not us.
Agreed.
Okay? If their evaluation, because of their tool, is to do an X-ray, the hematologist tool to do an evaluation is gonna be a blood draw. Okay? So, I don't know, somewhere in the near future, somebody's gonna say, ask the question, can physical therapists can physical therapists refer for lab work?
Yeah.
Okay, you need to know who you're sending it to, okay? And can that person then accept it from you? If they can't, you gotta figure out a way around it to get your patient what they need. And I believe what I'm hearing is that there are practitioners that have relationships with radiologists that say, send me your patients, we'll get this taken care of. And I believe we have someone who is not a licensee looking for a question, all right, has a question, looking for an answer. I've got PT sending me business, can I take it from them? Are y'all capable of sending me this business? Yes, yes, yes. Are you capable of taking it? I don't know.
Keep it to take
Oh, yeah, so what world do you live in? Oh, physicians can opt out of Medicare,
Right.
patient by patient, we can't yet, okay? So they could say, oh, okay, they'll do it for cash, cash is king, and these guys they gotta pay for their magnets. And this gentleman isn't in the hospital scenario, so he didn't ask, do you have to send it to the admitting physician? He's in an outpatient, independent facility, competing with healthcare facilities, competing with hospitals, wanting to know, hey, I'm getting this from you guys, is it okay? Am I breaking y'all's law? Are these guys capable of doing it? We have to give him the answer.
Kudos for him for asking.
Yeah,
Great discussion. I feel good about that.
yes. Okay, so executive director and
Does anybody else have anything? to
legal
add?
staff,
that's good.
yes. Any comments from the public at this
I
time?
hate to do this.
Yes.
Okay, is it worth providing clarification to the person who wrote this email? Because in question 1, it says referring in parentheses, writing the physical order. So is it worth clarifying that we are referring, we are not writing a physical order? Is it worth sending that clarification, because he seems to be using the term synonymously, referring, and then with parentheses, writing the physical order. But worth clarifying.
Let's see how y'all write it up and then
Yeah.
we'll talk about
And
it.
then we'll-
We'll revisit it
that's
then.
Because obviously in some form or fashion, you're gonna have to either write, is it the writing?
Is it writing a referral?
Is it, because you gotta write the referral, when is the referral?
It's the word referral, but he's saying referring and then writing the physical order.
Right.
That's using synonymously, which I think is our big hangout. So if we clarify, hey, we can refer, but we can't write this. Then we're-
Thank you.
Okay, I see Amanda has her hand up in the audience, Amanda?
In the audience.
Yes.
She's in
Hi,
the
can y'all
audience.
hear me?
Yes, ma'am.
The reality show, Amanda.
Okay, great. Thank you. Amanda Brewer, physical therapist. I would like to provide a public comment. And I was just going to say that I'm not sure if y'all have reviewed, but in 2016, the APTA hired an outside firm to review state laws, regulations, and rules and legal opinions surrounding imaging referral by physical therapists. So this outside firm conducted legal research between 2016 and 2019. And then APTA since then published numerous documents surrounding their findings. One of them was for the state of Arizona. And in Arizona, I think it was in 2017, what they were citing in this document prepared by APTA was the Attorney General analysis. And this was surrounding registered nurse practitioners However, it centered around the ability, basically the same thing. What is the definition of use in the context of X-ray, and as opposed to ordering? So in summary, and I can provide y'all with a link in the comments if you would like. But what they found is the term use in context of X-ray regulations refers to the physical application of radiation, not ordering or interpreting X-rays. So the courts interpret statutes based on plain language and commonly accepted meanings, and the term use here signifies direct physical manipulation of X-ray equipment. And then additionally, I was just gonna say, like, from my perspective, I don't feel that the Practice Act explicitly prohibits PTs from referring patients for diagnostic imaging, but it does specifically address the use of X-rays, radium isotopes, and ionizing radiation for diagnostic and therapeutic purposes. So that, in my opinion, pertains to the direct application of these technologies by the therapist, not the act of the referral. And additionally, in our in section rule 341 for documentation standards, 341A1, I know this isn't, wasn't written at the time, with the intention to apply to this, but it does state a prescription or referral, if it exists, may initially be a verbal order and may later be confirmed in writing. So even that language there kind of suggests that referral and order, are related, it appears.
Thank you, Amanda.
Yes,
That's
thank you.
helpful.
Yes.
What was that again?
Thank you. I'm gonna,
What was that reference again?
341A1.
341A1?
Yeah, and please send us that, yeah. And so also, it was in the early days of trying to hammer through referral versus prescription, okay? So referral is evaluate and treat, or here's the problem. Whereas prescription, they told you what to do. So if indeed in the old days, if you accepted the patient under prescription, all you could do what was on the prescription. You couldn't add to that, okay? So, we have prescription, we have referral, we have order. And again, gone to this, we can accept them verbally, followed by something in writing. So to put it in writing, I think everything we do has to be documented in writing. And so the question is now referral versus order.
Yeah. But she's right.
Yes.
It does say.
Yes.
Referral may be an order.
Referral,
So that's
yes.
interesting.
Okay.
And that's what I was looking for. That's why I was looking for the definition. I wanted to see what was in the Practice Act,
Yeah.
and it's a lot of pages. So thank you very much for
Yes,
helping us
Amanda,
with that.
always. Okay, so that doesn't change our answer.
Nope.
That will help guide the response from legal and staff.
So I'll make a motion. We okay? I make
Yes,
a motion?
ma'am?
Do you have the motion up on the screen?
Right here's what was prepared.
I move to authorize the board attorney and executive director to draft a response to both questions related to imaging for the board to consider at the next board meeting.
Second.
I have a motion and a second, moved by Katie, seconded by Lee. All those in favor, so we've discussed this. Any further discussion? Pertinent to the motion now. We're answering two questions. Any discussion, input from the audience? Okay, if not, I'd like a roll call vote, please.
Okay, Danny Lewis?
Yeah.
Yes.
Adam York, yes. Katie Britton?
Yes.
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 Phil Page, yes. Deandra Narcisse?
Yes.
Lee Riley, yes. Ode
Yes.
Coburn, yes. The yeas have it.
The yeas have it, which could indicate that the roll call vote was unanimous.
Sure.
Thank you all for that discussion, very healthy discussion. All right, next we have a question that we've received, an inquiry from a licensee asking about using a massage therapist as a PTA in their clinic. The next slide is a draft of the response. Again, let's read do we have the full question?
I put it in my response.
That was the previous, oh, yeah,
She restated the question.
yes.
Right, I don't think, yes, okay.
I just removed the
Yeah.
first sentence.
So I don't think she asked, can the massage therapist function as a PTA? Her question was, can I use a massage therapist in the clinic? And then my documentation and oversight of them would be similar to that of a PTA every 6 visits and updating the plan of care.
No, the question is, can a licensed massage therapist treat patients, document and bill underneath a DPT similar to a PTA?
No.
Oh.
No.
That's the question, all right?
Wait, where's that? Oh, okay.
All right, so here's our,
Yeah, okay, sorry, go back.
all right, so we have our draft response here.
I think you're jumping in the answer to the PT technician. I think you should answer the question the way that it's asked. So a massage therapist who is not licensed as a PT or a PTA working in the PT clinic would not be
Able to treat
Would
patients, document.
not be treated similar to a PTA because they're not a PTA. I think you need to say that,
Yes.
period,
Period.
end of story.
Checking that line.
But like, I don't even think we need to, I mean, like, answer the question.
A licensed massage therapist.
It's not a
is
PTA.
not a PTA and would not be able to treat patients, document and
And bill
bill.
similar
CPT
similar to a PTA.
Here,
As our PTA, would you like to add to?
No, I think.
as our PTA that was a massage therapist.
Oh, true, yeah.
At a physical therapy center.
Yeah.
And it was completely separate. If I did massage therapy, I was treating under a certain rate, and if I was not, I was checking at under a certain rate. It was completely two separate things.
You were not acting as a PTA. as a massage
With
therapist.
that check,
No.
you could do massage to your therapist's patient if he so chose for you to do.
We didn't do any soft tissue work.
Well, and then you didn't do any soft tissue,
Yeah,
but
as the tech, as the massage therapist in a separate hat.
yes.
I got
I did
it.
that.
I got it. Okay, so, and then the rest of it's good?
I don't think you need the rest of it, because they're not, like, I think you should answer their question. Just like we do with everything else, like, if you want to come back with another question, come back with another question. But the answer to this Caroline's question,
Who's not a licensed PT, PTA working in a PT clinic and following a PT clinic would be considered, I would just say, would not be able to treat patients, document and bill underneath a DPT.
similar to a PTA.
So no, in the state of Louisiana, a licensed massage therapist is not allowed to treat patients, document and bill underneath DPT similar to a PTA.
Because they are not a
Because they are not.
PTA.
Yeah.
There's no similarity. Either you're a PTA.
Right.
And you're regulated by the board.
Right.
Or you're not.
Okay.
That's a great question.
Yes,
All right, got it.
yes.
And I
And
don't
then
have
we can-
anything to cite in that case, so.
What is it? The answer to the question is in the
Question.
itself.
Right.
Yes.
Yes. Always.
I mean, again, I understand, we always assume we know what they're trying to get at, ask the
That's the
question,
question.
you know?
Got it.
I don't want to assume what you're trying to ask the question.
Okay.
Do we need to ask for public comment on this?
Do we have any public comment on this subject?
I have a question. This is Amanda Brewer again. I'm sorry. I was trying to pull it up, but y'all moved quickly. So how would, does this affect the way that we currently interpret the way that a tech can work under, an unlicensed personnel can work under APT?
No, that has its own rules and regulations.
Yeah, an unlicensed rehabilitation technician is not functioning in the role of PTA.
Correct.
Yeah.
Okay, because
Because
they
they're-
use the word similar to a PTA.
Right,
Yes.
right.
Yeah, and 6 visits and stuff. Okay, thank you. Appreciate
Right.
it.
So they're wanting, yeah, we don't know what they're wanting. Yes, we're
Yeah.
correct.
Thank
Yeah,
you.
we don't know. what they're-
Yeah. And unlicensed technicians can't bill. They don't document in the medical record and they don't bill and, you know, and so forth. that all that responsibility is responsibility of the physical therapist.
They can assist you in doing what you're doing.
Right.
You can bill for some of the things that they do.
Right.
They don't bill. More likely than not, they're not doing the documentation. They may document that they did something and it was accomplished. But they're not writing the documentation.
Right.
They're not doing it with the physical therapist, not watching and only seeing them every 6 visits. That's continuous on premises supervision.
Right.
Yep.
Direct supervision. So yes.
They're not similar at all to a computer.
No,
They
not
have
at
their own
all.
set of rules.
Not a rule, not at all. All right. That concludes the business of the board today. Are there any public comments in general? Anything else to be brought before the board? I'll surely entertain a motion to adjourn.
Motion to adjourn.
We have a motion to adjourn by Phil. Do we have a second? We have a second. All those in favor? Vote by saying aye. All those opposed, nay. The ayes have it. This meeting is adjourned.
Who
Thank you.
seconded?
Please second. Great discussion.